Capitol during day 7 of Ken Paxton's impeachment trial.
So it started when Paxton's mistress was called to testify, but right before her testimony, things changed. She left, and Lieutenant Governor Dan Patrick, who is acting as judge, said she was no longer available to testify. Then the lead impeachment prosecutor made a mistake, one that Paxton's attorneys jumped on in an effort to get the whole trial thrown out. Fox 4's Peyton Yeager breaks it down during the tail end of the testimony today. She's in studio. Peyton.
Steve, due to a technical issue this morning, we essentially had to wait all day on day 7 of the trial to see if Paxton's mistress, Laura Olson, would take the stand. We know she was present at the state capitol and has never spoken publicly before. However, just before 5 p.m., she was deemed unavailable to testify. Late Wednesday, the highly anticipated testimony from Laura Olson, the mistress of suspended Texas Attorney General Ken Paxton, was called off at the last minute. Olson, pictured here with Lieutenant Governor Dan Patrick back in 2018, was seen at the state capitol Wednesday. But Lieutenant Governor Patrick, who was overseeing the trial in the Senate, made a surprising announcement.
Members, for the record, the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify. As soon as we get the witness in, we can continue.
In the live stream, you could hear a few rumblings from the audience in confusion. The Lieutenant Governor repeated himself.
I said the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify.
Olson, pictured with State Senator Donna Campbell on a Bexar County GOP Facebook page in 2018, used to work for Senator Campbell. Evidence submitted by House managers allege Paxton misused his office to help his friend, Austin businessman and donor Nate Paul, who was under investigation by the FBI and has been charged with 8 felony counts. The evidence suggests Paul hired Olson at his business, making it more convenient for Paxton to be close to her. But Patrick repeated a third time Olson would not testify after all.
The statement has been made by the court. It says what it means. Both sides have agreed to that statement. Both statements have agreed to that statement.
According to media reports, Olson allegedly planned to plead the Fifth during her testimony, so both sides agreed to move on. We spoke to constitutional lawyer David Cole moments after the Olson decision.
She'd been summoned to come. The issue of whether or not she could be made to testify and assert the Fifth was still in play. The last bit of argument about that took place today, and the Senate made its decision during the course of the day, and that led to the statement about availability. I don't think they would have called her down there if they knew, that there just was going to be a no-go at the end of the day.
Cole says without Olson's testimony, it hurts the House managers.
Well, only 2 people know the truth there, Ms. Olson and Mr. Paxton. Neither one of them is going to be testifying now. So there's kind of a gap in that part of the story that the House managers previewed for us in the opening. We just don't know the why now.
Shortly after, the House impeachment managers rested their case. However, House lawyer Rusty Hardin admitted he accidentally rested too early before Paxton's team could cross-examine one of the whistleblowers in the case.
The court is having to put up with a screw-up by me. I apologize, but I would very respectfully like for him to go and do his cross.
I don't have to do a cross. He rested. I will recall this witness.
This back and forth caused Paxton's defense attorney, Tony Busby, to file a motion for a directed verdict, arguing there is insufficient evidence in the case against Ken Paxton. Ultimately, this would have ended the trial early. At the same time, House managers were proposing a rule change, adding that Paxton be banned from running for office again in the state if he is convicted. But after a debate behind closed doors, both sides decided to withdraw their motions, and the trial would continue. So after...
All right, so good morning to everybody in the stream on all our platforms. Lieutenant Governor coming in after an incredible Wednesday of political theatrics, tension, and tightrope in this impeachment trial. He's getting ready to address the body.
Well, I see the bagpipes are gone, but the crickets are still here.
day 8, and we're going to see what happens here. We do know Paxton's defense team's planning to call a political science law school professor from University of North Carolina who is referred to as an impeachment expert. We'll see what that testimony is. And see if Mr. Patrick gives us an indication of how much time each side has remaining.
Senator Hughes, I believe you're doing the prayer this morning.
Well, let's go to the Lord in prayer. Heavenly Father, when we consider who you are, the one who has always existed before time, way back into eternity, who always was and always will be. When we consider that you made everything we see, things we cannot see, us, every molecule, every particle of each of us, just because of who you are, we owe you everything. We owe you our lives. And Father, when we consider on top of that all that you've done for us, the gifts that you lavish upon us, that you heap upon us, our very lives, and especially those of us in this country and this state, the special blessings we enjoy of liberty and opportunity and justice, unknown in the history of the world, uniquely given to us here from your hand. We know we each have a responsibility in preserving those things as stewards, each one of us, whatever our role. So, Father, we thank you. Thank you for who you are, for what you've done. We confess our failure to acknowledge you as we ought, to look to you, to humble ourselves before you. And we just thank you for loving us. The ultimate expression of your love for us, that Jesus Christ, God's Son, God himself, would humble himself and come to this earth and take on human form and live that beautiful life, and then pay the penalty for all of our sins on the cross, and then raised from the dead on the third day. We thank you for him. Your word says that since you gave him for us, there's nothing you'll hold back. So, Father, we ask you for wisdom that you've promised to give. We ask you to be honored in these proceedings today by everyone here, whatever their role. Thank you for loving us so much. In Jesus' name we pray. Amen.
Thank you, Senator. You may be seated. Members, can we have a little quiet in the courtroom? Can I have both parties come forward?
This is kind of the habit now to start each day with a little sidebar. Again, as I mentioned, that's because we're at a very critical juncture now, and the respondents, or the defense, Paxton's team, presenting their witnesses today. We don't know how many they're going to present. We don't know how many they think they need to put forward at this point, where they feel they are in this case. We know we're not going to see or hear from Ken Paxton except on social media. He posted, as all this was happening last night, and motions were being filed and motions were withdrawn.
Is the defense ready to call their first witness?
He posted on X that he's going to join Tucker Carlson.
And who would that be?
To talk about the 2 weeks of this trial.
Justin Gordon.
Bailiff will bring in Justin Gordon. Counselor, state your name for the record.
Of course, Allison Collins.
I always give you the time check. Members, House, you have 2 hours, 34 minutes, and 49 seconds remaining. A respondent, 8 hours, 38 minutes, and No seconds remaining.
So Paxton's team has 8 hours plus remaining. Doesn't mean they'll use it all. So Justin Gordon is an assistant general counsel, was in the AG's office, may still be
Were
in
you
the
here on
AG's
day one
office.
to
He
be
was
sworn in? I
the
thought
chief
so. Please have a seat.
over open records.
Good morning, Mr. Gordon. How are you today? Could you please turn on your microphone and go ahead and adjust it pretty close? The acoustics in here can be a little difficult.
Is that okay?
Yes, that's much better. Could you please state your name for the court?
My name is Justin Gordon.
And where are you currently employed?
I'm employed in the Open Records Division of the Texas Attorney General's office.
And what is your position there?
I'm the Open Records Division Chief.
How long have you been the chief of the Open Records Division?
I began in 2015 at the beginning of General Paxton's term.
Excuse me, I think you're going to have to speak louder and a little closer, okay?
I began in 2015, in January of 2015.
What does the Open Records Division do?
Our division handles a number of responsibilities regarding the Texas Public Information Act. That includes enforcement and review of public information decision requests. We also provide training for governmental bodies on the Public Information Act.
Okay, I'm going to ask you just to slow down a little bit while you're talking, okay, to help the court reporter out. Can you tell us how many public information ruling requests your division handles a year?
Last year we did over 40,000. In the previous fiscal year we did just under 40,000.
And does your division maintain a record for each ruling request?
Yes, we maintain both an internal record of our ruling requests. We also post all of our letter rulings on our website after they are issued.
Do you recall a request for ruling from the Texas State Securities Board in the fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of that ruling request?
I do not believe any records were released in response to that ruling request.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was.
How frequently does the Open Records Division receive requests for reconsideration or complaints about a ruling?
That's very common. I don't have an exact number to provide you, but that's something that we see certainly on a monthly basis, if not weekly.
Were you also involved in deciding a request for ruling from DPS, the Department of Public Safety, in the spring of 2020, which we're going to call the big request for ease of reference? Do you recall that one?
Yes, I do.
Was that also related to Nate Paul, if you recall?
It was.
At some point, as one of your duties, as part of your employment, did you make a summary of that file?
I did.
Your Honor, if I may approach the witness.
Yes, you may.
I'm going to approach with what is marked as AG.
Hold on one second. Yes, Senator Whitmire? Okay. Allison, you're going to have to speak louder as well.
Even louder. Okay.
That'll do it. That'll do it.
I'm going to approach with what has been marked as AG 205, and it has been pre-admitted.
Okay. Members, do you need for us to review with the court reporter what has already been said? You're okay? Everyone's okay? You do? Okay. Okay, so let's go back to where you began. The question on DPS, Senator West? Securities. Okay, let's start over.
No problem. Do you recall receiving a request for ruling from the Texas State Securities Board in fall of 2019 for some records related to Nate Paul.
Yes.
Do you recall if any records were released as a result of ORD's ruling?
No, I do not believe any records were released in that ruling.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was a request for reconsideration.
How frequently does ORD receive requests for reconsideration or complaints about a ruling?
That's very frequent. I don't have an exact number to provide to you, but it's something that we see, if not on a weekly basis, then certainly monthly, several times a month we receive reconsiderations.
Do you also recall being involved with a request from DPS in the spring of 2020 related to Nate Paul?
Yes.
Now, we've been calling that the big request to help distinguish them. Will you understand what I'm saying if I call it the big request?
Yes.
Thank you. And at one point, as part of your employment, did you create a summary of this file?
Yes.
Your Honor, I'm going to approach the witness with what has already been admitted as AG 205. Mr. Gordon, do you recognize this document?
I do.
Is it a fair and accurate depiction of the summary that you created for this file?
Yes, it is the summary I provided for the file.
Well, let's talk about it. Let's walk through it together, okay?
Okay.
First, how would you describe this particular request, the big request?
It started off as what I would have characterized as a relatively routine request from the Department of Public Safety. Department of Public Safety routinely briefs our office on law enforcement matters. They, again, very commonly submit rulings to our office. However, as the ruling was being reviewed, it took a turn procedurally, and then there was a number of procedural irregularities that occurred with the file that made it unique.
And Eric, if you could please pull up AG Exhibit 205 and highlight the first paragraph, please. And Mr. Gordon, I think it's consistent with what you just said that there were procedural issues that made this file unique. Is that correct?
That's correct.
Okay, and when was the request received by your office?
On March 13th.
Okay, and at this point, this is when you're talking about it was very routine?
Correct.
Do you recall what exception DPS was asserting?
They sought to withhold the information under the law enforcement exception. That's Government Code Section 552.108.
Is that, there are generally two types of exceptions under the PIA, is that right?
That's correct. There are two, we characterize them as two separate types of exceptions. There's an exception for confidentiality provisions that we would also call mandatory exceptions. And there's a type of exception that is just a normal exception to disclosure that we would call a permissive exception to disclosure.
And which type is the law enforcement exception?
Section 552.108 is a permissive exception. The government body has the option to raise it or not to raise it.
What happens if they do not raise it?
Nothing happens if they do not raise it. We won't address it if they do not raise it.
So if they don't raise it and you don't address it, what's the end result as it relates to the request? Are those records released or are they withheld under the law enforcement exception?
Oh, they would be released. They would not be withheld under the law enforcement exception.
So let's talk about some of the procedural irregularities in this file. I'm now in the second paragraph, Eric, if you could blow that up for the senators. Where did this file first start to take a turn towards the unique?
Where you have it highlighted, I described that.
Excuse me 1 second. I'm very sorry. I'm very understanding with 8 grandchildren and a lot of little ones, but we really can't have a distraction. I'm sorry. Might have to step out. I really apologize, but I don't want to distract the jurors. Very sorry for that.
May we continue? Thank you. I believe you were about to point out to us where the procedural issues started to arise in this file.
Sure. So we have a statutory 45-day deadline by which we have to issue all of our rulings. That's from the government code. And as we were approaching that deadline, the DPS submitted a follow-up correspondence to our office explaining that the requested information may implicate the interest of the FBI. And at that time, they also submitted additional records. So in the initial submission, they only submitted a representative sample, which they are permitted to do. In fact, the PIA requires them to do that if the records are voluminous, and they had done that in the initial submission. However, when they submitted the subsequent submission, they submitted additional documents, not the same representative sample that they had submitted earlier. And the new documents were substantially different than the documents that had been originally submitted and were of a different character. So they
and I'm going to stop you. I think that's a great spot. And just to summarize, so essentially, the original representative sample that DPS sent in did not match with the sample that they later sent to your office in May of 2020. Is that right?
That's correct.
And they sent that second sample at the time that they were notifying the FBI that they might have an interest in the file, in the information being sought by the request?
That's correct.
Is that considered a procedural violation under the Public Information Act?
Yes, governmental bodies are required to submit all of the records that they want a ruling on or a proper representative sample by the 15th business day after receiving the request, which had been substantially before this time period.
So this sample was also late, is that correct?
That's right. That's correct.
What is the consequence for a procedural violation of this nature?
Under the Public Information Act, failure to comply with the procedural requirements in requesting decision from our office results in a presumption that the information is released unless the exception that they're raising constitutes a compelling exception. And our office has concluded that Section 552.108 does not constitute a compelling reason. That's a fancy way of saying that they waive that exception, and they would waive it for the information that they had the procedural violation on.
And that would be all of the information that they provided as the second sample in May of 2020?
Correct. Anything in that representative sample, the second set of documents that was not in the first set.
And is it your understanding that that second set of documents had also been provided to the FBI?
Oh, I'm not sure if they provided that second set of documents to the FBI. I don't remember that.
So this late, was the notice to the FBI also late?
Yes. Governmental bodies, there are procedural requirements and there are also due process requirements in the Public Information Act. And because of those deadlines, there are certain notice requirements. So the only notice requirement in the Act that applies to third parties is in Section 552.305. That section requires governmental bodies to notify third parties if their privacy or proprietary interests are at issue, and that notice is supposed to come within 10 days of receiving the request. Otherwise, there's also the due process element of that notice needs to be made in time for those comments to be received by our office before, in time for us to be aware of them, and also in time for the requester to receive notice.
And in this instance, was the notice given close in time to your statutory deadline to issue a ruling?
Yes, we received it just a couple of weeks before our 10-day deadline or our 45-day deadline.
The second sample of the second set of documents that you were provided by DPS, how were those provided to you? Hard copies on a CD, do you recall?
I don't recall if they were a CD or if they were a hard copy.
Okay, so you sent this, the notice went out to the FBI and you received a copy of it. What happens next?
So at that point, we were kind of up against it with respect to the timelines. You've got the highlights here with respect to the to kind of what was going on in this file. We had also been notified by the requester in this file that he had filed a lawsuit against DPS in this case, which added a whole nother layer of complexity to it. Because the late notice, because the notice was received so close up against our 45-day deadline, we didn't feel like the third party who was notified, FBI, would have had time to submit comments to our office in time, and so while we were waiting for those comments so that we could receive them and review them from the FBI, we took a 10-day extension on it, and again gave ourselves a 10-day extension, which is permitted under the PIA.
All right, I'm going to ask you just to slow down a little bit, okay? You're doing great. So you extend it for 10 more days. Does the FBI eventually provide your office with comments?
Yes.
And do you know if the FBI also provided the requester with a copy of those comments?
At the time, when we identified the documents, we actually only found the comments because the requester let us know that he had received comments, and so then we went and tracked them down. This is at the beginning of COVID, so our mail intake was kind of thrown off. So when the requester notified that we had received comments, we went and tracked those down. To add another procedural complication to it, at that time, the requester notified us that his copy of the comments had been completely redacted. Our copy did not have any redactions on it. It just had a reference that at the end that the version that had been provided to the requester was redacted.
In your honor, if I may approach with what's been marked as House Managers 46 but has not been admitted into evidence yet.
You may approach the witness.
Mr. Gordon, do you recognize the document that I placed in front of you?
I do.
What is it?
This appears to be a copy of our internal ruling file pertaining to the DPS file that we've been discussing.
And does it appear to be a complete and accurate copy of the file?
I'm sorry, I'm just double checking.
Take your time.
Yes, it does.
I appreciate your thoroughness. At this time, we'd move to admit House Managers 46.
Any objection?
Mr. President, no objection to the admission. However, in this document, it contains a copy of the unredacted FBI brief, which not only contains personal identifying information, but a number of sensitive information of the types of operations plans and other sensitive law enforcement information, which Nate Paul had been trying to get for a while. If it comes in, we just ask that it be redacted because that information has not been publicly made available.
And Your Honor, we'll get to that on the next request, but I will represent to this court that that is not the case. As has been discussed by other witnesses, this brief was in fact released publicly.
Okay, so they did not object, and I'll let her go along with her line of questioning, and we'll get back to that issue, but thank you for bringing it up. Go ahead.
Thank you. Eric, if you could pull up towards the back of that Exhibit 46, the Bates number at the bottom is 8803.
Mr.
And
President, I do have to, I'm sorry, before this is shown to the jury, there is personal identifying information
and
that
sir,
has not, may I finish?
Stop not talking over each other.
That has not been released publicly. It may have been released to Nate Paul at General Paxton's direction. However, it has not been made public to the world at large.
Okay.
There's very sensitive law enforcement operation plans, details about search warrants, how investigations are done, and also specific names of individuals that are identified and involved.
Come on up to the bench. Please come up to the bench.
Yes, sir.
Well, this is the first fight of the day over evidence that possibly could be submitted. Right now, it's on the verge of being submitted, and prosecutors for the House are fighting its admission because of secret information included in this huge packet and open records request. They're saying, listen, this includes how investigations are taking place and sensitive information like names of people, agents, that's not been made public, and we object to it being released. And if it's going to be released, we want all that information redacted. So Justin Gordon is Assistant Attorney General, and he's Chief of the Open Records Division. And he's talking about a couple of open records requests that came in 2020. The quote-unquote big one, a DPS request, in March of 2020. We will also learn, perhaps, that Nate Paul also made open records requests for information. And so this is all part of that, part of the conversation. And at one point, we heard over the last many months a suggestion that Attorney General Ken Paxton encouraged Nate Paul to make open records requests so he could learn who was looking at him and what they might be looking at. All of that alleged over the last many months. And again, this is right now a battle over whether this evidence, this open records file, can be entered into evidence, into testimony, and have Justin Gordon go through it. So another issue here is the time. The defense, the respondents, they have 8 hours. At the start of today's testimony, they had 8 hours and 38 minutes. The House, 2 hours, 34 minutes, 49 seconds. And so they have to really be careful in how they use their time, else they'll be out of time as it relates to testimony, to cross-examinations, exploring evidence, and they'll have to sit silently while Paxton's defense team, the respondents, go through their witnesses if they so choose. And so part of Justin Gordon's testimony, again, Article 3 abuse of the open records process. And the allegation has been raised. One of the articles of impeachment is that Nate Paul was encouraged to file this open records request, and that Ken Paxton went to great steps to not only encourage but move his staff to provide him the information he wanted so that he might be able to see who's looking into him. So part of what Justin Gordon may testify to and try to show, the Paxton's attorneys will try to show through him, is he didn't make it easy for him, and we didn't just roll over and give it to him, and that's not the case. We'll see what the testimony bears out. There
Yes.
So
Doc timely fashion. In the way that they
of
would not apply it.
permissive at that meeting, okay?
Primary options were yeah. It could have.
Please take it off. OAG. Is this or ORD to
Take it back and maybe simplify. Court even
a good
because that, you know, we thought that was okay, and then they would, because they do it routinely, I mean, they request decisions from us routinely, they could have seen that as a, oh, well, now we've got the stamp of approval to do this, and now we'll keep doing it.
And now, while all of this is going on, were you made aware of a request from Mr. Larson for a copy of the FBI brief?
Yes.
How were you made aware of that?
That wave that's in Dallas right now bloomed up.
There's not much left to the west of that by Mineral Wells. So I think it's going to be about 2/3 of us. That's it. And then tomorrow we'll have some in the morning through noon, same time, especially west. Saturday, 30% showers and storms. And that should be it for a while as temperatures warm up next week.
Well, if you're looking for a reason to swim in a pool, here is one. A massive gator was caught on camera swimming towards children in southeast Texas.
Gator spotted over the weekend at Raven Lake. This is in Huntsville State Park, 70 miles north of Houston. Now, here's the deal. Even though you see that there's like a swimming area, I mean, there's a platform and all and everything, and the parents rush to get the kids out, apparently there are signs saying, don't swim here, or just be aware that there might be gators.
Gator was just aiming for her. It was like a movie scene being real.
You just fight or flight. Luckily that rope was there. We were able to use it to distract them.
Yes, there are signs at Huntsville State Park warning guests about the danger. This is a second one in as many weeks to get into the swimming area at that lake.
I wouldn't be standing really close to the shoreline either.
Well, a lot of people say
we were the ones who maintained that as part of our work file.
Have you reviewed the ORD file for the FBI brief request before?
So just to clarify, our office, or my division, does not have a file on that public information request. We have the file that's here before me as this PDF, and yes, I have reviewed that, but I have not seen the opinions file or the public information office file involving that ruling request for that brief.
Now, in the file in front of you, there is a copy of the unredacted FBI brief, correct?
That's correct.
Would you take a look at it, please?
Okay, I'm looking at page.
And what I want you to look for, you're the chief of ORD. I want you to set aside law enforcement exception for a moment. I want you to look at that brief and let me know if you think there are any mandatory exceptions to public disclosure that are flagged within that brief.
Not to nitpick, but there is Mr. Larson's email address is at the end of the brief, but he was the requester. So no, but other than that, I don't see any confidential information on the face of the document.
Thank you. And just one more thing on, forgive me. Your Honor, if I may approach with what's been marked as AG 34.
You may.
Mr. Gordon, do you recognize the document I placed in front of you?
I do.
And what is it?
This would appear to be the internal file for the opinions ruling request that we've been discussing that was Mr. Larson's request for the unredacted FBI brief.
Does OAG receive requests for copies of PIA briefing on other occasions?
Yes.
Does that occur can you tell us with any sort of frequency how often you receive that type of request for briefing?
If I had to guess, I'd say it would be once a month, probably less than once a month. It's not very common. It's not a weekly occurrence.
And were you familiar with Joe Larson?
Yes.
How?
I've worked with Joe Larson for a long time. He is a well-known open government lawyer. He's also involved with the Freedom of Information Foundation, which our office has partnered with in the past to perform trainings. He's routinely sought after to provide input on Public Information Act requests. I've also observed a number of cases that he's handled because he ends up often handling important Public Information Act cases. So I've known Mr. Larson for a long time.
Based on your knowledge of Mr. Larson and working with him, was it surprising or unusual for him to submit a request for a copy of that redacted brief?
No, I wasn't surprised at all that Mr. Larson would ask for that.
And you started to walk us through what OAG does when it receives a request for documents that OAG itself holds. I just want to make sure that's clear for the jurors, okay? So let's walk through it. So what's the first step OAG would do when it receives a request for records that it itself holds? The first step OAG would do when it receives a request for records that it itself holds?
That would be received and handled by the Attorney General's Public Information Office.
Objection, Your Honor. I apologize to the witness, but at this point, it's clear from the witness's own testimony that once this request that's about to be discussed was made, it went to a different division, not his, that he does not oversee, and he's previously testified that he was not involved. So any information that he has about specifically how it was handled or by whom would be hearsay or speculation.
Your Honor, right now I'm asking him to walk through the general process of how this is handled, which is something that as the chief of ORD, he is intimately familiar with.
The witness can answer. Overruled.
When a request comes into our Public Information Office, the Public Information Officer will identify the divisions that they believe maintain documents, and they will notify those divisions. Those divisions then collect the information. Generally, we collect the information unless there's some issue with the request, like we don't understand it or it would require a cost estimate. Those divisions, my division in that case, will respond back that we maintain documents, and then we'll follow that up by providing those documents. If a decision is required, then the Public Information Officer will prepare that decision, and they will send it to our division. As soon as we see that we've received a request from the Attorney General's office, it gets segregated out, and at this time, it would have been forwarded to the Opinions Division.
So ORD is not deciding decisions on documents held by ORD, is that right?
That's correct.
Leading.
Sustained. You can re-ask the question.
I think the point's been made, Your Honor. I'm going to move to admit AG 34. It is an internal business record of OAG. It was actually given to us pursuant to a business affidavit that has been on record for more than 14 days.
And Your Honor, objection? As we discussed at the bench, the issue is not the business records affidavit. It is protecting the sensitive information of law enforcement, how they conduct their investigations, and specifically the individuals involved. An exact identical copy of the same brief we just talked to you about at the bench is also contained in this document. And so I have no objections as long as she's willing to protect law enforcement and the integrity of their investigations and redact that sensitive information. With those redactions, no objection.
And Your Honor, the chief of ORD has now looked at this brief and told you that there were no mandatory exceptions and no confidential information within that brief. He's also testified that once documents are given to one requester, they are given to any subsequent requester. They are considered public. And so I do believe that he is one more than very highly qualified to speak to this file, and that there are no confidentiality concerns raised within it based on this witness's testimony.
Brief response, Your Honor?
Yes.
Everything my colleague said misses the point. All I'm trying to do is make sure that the sensitive law enforcement information, which is in front of you, the identities of the individuals involved in the investigation, how they conducted the investigation, their sensitive operations plans, their sealed search warrant affidavits and the details contained within, how they communicate with each other, who was on those communications, and when they were sent, all of that information I just would ask would be redacted.
And Your Honor, very quickly.
Stop. Don't talk over each other. Court reporters have a tough job as it is. Come up for a moment again.
right, so we're in the sidebar. It might soon end. Again, we've been listening to this conversation, this testimony about a open records request and what was wrong with it, and they've talked about the requester, but they haven't provided a name yet. This is an open records request from Nate Paul. It's about the raid on his home or following that raid on his home in 2019, that raid by FBI and DPS. So this was an open records request filed by Nate Paul with the help of an open records attorney, Jeff Lawrence. You've heard through Justin Gordon talk about the quote unquote things wrong, irregularities or procedural violations with the request. Again, one of the allegations, Article 3, is that Ken Paxton encouraged Nate Paul to file an open records request to find out what was going on, who was looking into him and why, and encouraged his staff to make that information available. Justin Gordon's testimony is to suggest that's not so. And that's where we are now. In fact, he talked about the problems with the request on its face and what they did to address those problems and why they were uncomfortable with the way it was presented and made changes, because he said, you know, we did not want people, other agencies that we work with, to have complete documents redacted, and you know, if we started that policy and gave that information out, other people would want it and expect it going forward. And so we believe that's where he's going, to try to say, look, this was from Nate Paul, but on its face, it had issues, and we dealt with those issues. I met with the Attorney General about it even, and we made decisions not to release it all. That's where he's going to ultimately end up. But this debate has been about what's in that open records request. And that's where the pause is now.
Members, we will take a break in a little bit, just a little bit. Everybody be seated, please. So as we have been going through this testimony, slowly continue.
Mr. Gordon, the file placed in front of you marked as AG 34. Is there any search warrant inside this file?
There is no search warrant inside this file.
Are there any emails between the FBI and DPS inside this file?
There are no emails between the FBI and DPS in this file.
Did you notice any victim information inside this file?
I did not.
And if the redacted FBI brief had been released to one requester, it would be released to other requesters?
That's correct.
And you've had a chance to look at this file now, correct?
Yes.
And at the back of it, you'll see that, well, let's walk through it. So I think you've testified that based on this file before you, does it appear that OAG sent a notice to the FBI about this request for their redacted version of a brief?
Yes, it does.
Did the FBI respond?
Yes, they did.
And I want you to take a close look at their response brief, and specifically the last page under the signature line. It's the last page of the file. Are you there?
Yes, that's page 6 of the draft.
Witness needs to stay close to the mic and speak up.
Does it indicate that the version sent to Mr. Larson was redacted?
Objection, Your Honor. The counsel is mischaracterizing the evidence and honestly misleading the witness. The document that she is...
You may answer the question.
On this brief, it does not say redacted after the CC list to Mr. Larson.
And this brief was filed by a Mr. McPhillips from the FBI, is that right?
That's correct.
And from the front of this brief, was it filed, and it's actually marked as received by Open Records on or about June 18th, 2020? Do you see that?
Yes.
And then I want you to look immediately in front of this brief is a copy of the redacted brief at issue. Do you see that?
I'm sorry, would you repeat the question?
Yeah, if you keep flipping forward in the file, the next thing you see is a copy of the blacked out brief that the FBI had filed first.
Oh, I believe that's, I don't see in this.
The Bates at the bottom of the page I'd like to direct you to is 49982.
49982. Oh, yes, okay. That's the last page of the redacted version?
It's the last page of the brief that the FBI filed in May of 2020, right?
That's correct. I'm sorry, I was looking for the version that was actually redacted. There's no redacted version.
I apologize. There is no redacted version in here. And when you look under the signature, first, who signed this brief from May 2020 for the FBI?
Matthew Phillips.
So the same Mr. McPhillips?
Yes.
And underneath his signature line, what does it indicate next to Mr. Larson's signature? I mean, next to Mr. Larson's name on the copy list?
Next to Mr. Larson's name on the copy list, it says it was redacted.
So the first brief was sent to Mr. Larson, redacted. Is that what that represents to you?
Yes.
And so the second brief, the June 2021, based on the documents before you, was that redacted when it was sent to Mr. Larson?
It does not indicate that it was redacted.
Does that indicate to you that the FBI provided a copy of this brief directly to Mr. Larson?
Objection, leading.
Sustain, rephrase your question.
What does that indicate to you?
That indicates that they provided the same copy of this brief that they provided to DPS, not unredacted.
And I want you to take a look at this June 2020 brief and tell me how it compares to the May 2020 brief.
They look very similar. There is some different language certainly at the beginning, but they look very similar.
Other than the first paragraph, they are very similar?
Yes, that's correct.
So based on the documents in this file, does it appear that Mr. Larson that the FBI provided this information itself to Mr. Larson?
Yes.
And the very front of this file is the decision issued in this case. It starts with Bates 49954. Do you see that?
I do.
And you just looked at the FBI's June 2020 brief addressing whether or not that blacked out brief should be released to the public, right? You just looked at it?
I did.
Did it anywhere in there argue that their redacted brief should be withheld from public disclosure?
No, it looked like the arguments applied to the documents that were issued in the underlying DPS file.
And so when that happens, when the comments don't address the information being sought, what, in your experience in ORD, happens in a file like that?
In that case, we would not apply the exception to the documents that are submitted. We ordinarily, because this opinion was done by opinions, they use slightly different language than us, but we've got boilerplate for that type of circumstance. Either that the entity that submitted the arguments is arguing against the release of information that was not submitted to our office, or that the arguments that they've submitted don't apply to the information that is at issue. Because we have a presumption of openness, there has to be an exception to disclosure in order to withhold the information. And if it's a discretionary exception, it wouldn't be applied to information that they don't seek to withhold. If it's a discretionary exception, they have to seek to withhold it in order for the exception to be applied to it.
And the FBI, so the FBI just didn't address their redacted brief at all, based on this file, is that right?
That's right.
Which would result in what, ultimately, for the requester?
That would result in the information, that would result in the arguments that are raised not being addressed to the information for which there are no arguments. And if there are no other arguments, then the information would be released.
Okay, so I want to make sure we all understand what your testimony has been here today. So we had the first request to TSSB in the fall of 2019. Was any information disclosed to Nate Paul as a result of OAG's ruling?
No.
Then we move on to the big request to DPS in the spring of 2020. Was any information released to Nate Paul as a result of that ruling?
No.
And then we get to this third request. And what we see is that the FBI provided a copy of the brief directly to the requester itself. Is that right?
Objection,
right.
leading.
Overruled. Repeat the question and answer.
We get to this FBI request for their blacked out brief. And what we see is that the FBI directly gives a copy of the brief to the requester, to Nate Paul. Is that correct?
Objection, Your Honor. It should be made clear for the record that we are talking about two different briefs, one in May and one in June. And the one in June, yes, there's no dispute. The FBI provided that to Nate Paul's counsel. That is not the one that contains the sensitive information that we have been discussing.
Clarify.
Of course.
I sustain the objection. Clarify.
What we're seeing from this file is that the FBI provided a copy of its June 2020 brief directly to Mr. Larson. Is that right?
Yes, that's correct.
And you've also testified that that June 2020 brief is very similar to the May 2020 redacted brief, right?
Yes, that is correct.
And that ultimately, because the FBI did not address why their redacted brief should not be released to the public, it was released.
Objection, leading.
Sustain. Rephrase your question.
What was the ultimate outcome of the opinion on this FBI request related to its redacted brief?
The opinion concluded that the unredacted brief could be released to the requester.
And you reviewed that brief?
Yes.
And you did not see any mandatory exceptions within that brief that would require OAG to apply its own redactions before release?
That's correct.
Objection, leading.
Overruled.
That's correct.
And after this ruling in August of 2020 on the FBI brief, do you recall one way or another if Joe Larson, on behalf of Nate Paul, continued to seek information from public safety agencies through public information requests?
Yes, he did.
And how do you know that?
He continued to pursue complaints against the Texas State Securities Board all the way through September of that year, seeking to obtain documents that TSSB was withholding from him in the context of Public Information Act requests. And then that continued, throughout the summer and into the fall.
And after ORD rules on a request, what does ORD do with the documents that the governmental agency provided to you to make your ruling?
We send the documents back to the governmental body.
You don't keep a copy?
No.
Those are all my questions for this time. Thank you.
Thank you, Ms. Collins.
Examination, Your Honor.
Yes.
I'm so sorry. One thing, we are moving for admission of HM 46 and AG 34 based on this witness's testimony.
Your Honor, same objection. All we're trying to do is protect the sensitive law enforcement operations, who was involved, when emails were sent, what the subject of those emails were, what the FBI's operations plans were, how they work with the State Securities Board, the FBI, the DPS. If that information can be redacted, no objection.
Hold on. We've discussed this at length. He testified there was nothing confidential. The FBI could be here. They could be called.
Yes, Your Honor, or Mr. President, yes, that's correct.
Either one, doesn't matter.
Okay, yes, sir.
But they're not here.
They're not, however, I would like to, for the record, remind the court that it was Mr. Bangert's testimony opposite to Mr. Gordon's.
Your Honor, I'm going to insist that she not say testimony of another witness in front of this witness.
Okay. Both of you, just stop for a moment, okay?
Okay, so the meat of the matter is they're showing through Justin Gordon that Nate Paul's initial request for open records with the assistance of an open records attorney, Jeff Larson, were denied. His first request was to the state's securities board. That was denied. What they call, quote unquote, the big request has to do with Department of Public Safety, FBI, raids on his home and businesses. How did then Nate Paul get unredacted information? And what we heard in testimony is that the very file that was in question was actually sent to his attorney by the FBI, not the Attorney General's office.
Your Honor, if I could, I just want to make sure that there's no misunderstanding or misstatement here.
Article 3.
Jurors, please take your seats again.
I just want to make sure that there's no misunderstanding here, that you have a complete copy of those files in front of you, and you can see for yourself that there are no copies of search warrants, there are no copies of the actual emails within those files, which appear to be the documents that counsel is concerned about, and I just want to make sure that's clear for the record, that those documents are not in those files.
And we have reviewed them while up here, going through this testimony. Is it your representation as an officer of the court that this document has already been released to the public?
Yes.
Both documents?
Yes.
And that was the testimony.
It was.
I have to overrule your objection. We'll admit into evidence AG 34 and OAG Exhibit 46.
That should be HM 46 and AG 34,
Oh, I'm sorry.
Your Honor.
HM 46, yes.
Thank you, Your Honor. Those are my questions for now.
Yes. Your witness.
Good afternoon, morning, Mr. Gordon.
Please state your name for the record for the
Leah Graham. You talked about this decision being fact-specific. Do you recall that testimony?
Yes.
So let's talk facts. The requester in this case was Nate Paul's lawyer, correct?
Objection, speculation.
I believe that same testimony was elicited on direct that Joseph
overruled. Go
Larson.
ahead.
Correct.
We did not know that at the time. It's become apparent that that is the case now, but we did not know that at the time.
In your original opinion, as it relates to the request for the full release of the DPS file, was that it should not be released and that the law enforcement exception applied. True?
That's the big DPS file that we're referring to?
Yes, sir.
The original draft on that, I believe, did just address it under the law enforcement exception.
And that was your opinion that it should not be disclosed under the law enforcement exception, correct?
No, that was not my opinion. That was just the first draft that was on the ruling.
Who drafted the first draft?
I'm not sure if that was the drafter on the ruling or if that was me. I don't remember.
You had direct conversations with Ken Paxton about this specific request for a full copy of the DPS file, true?
Yes.
He made it clear to you that he wanted to find a way to release the documents that Nate Paul's attorney was requesting, true?
Objection, Your Honor. That's improper testimony through this counsel, assuming facts that have not been addressed with this witness.
Your Honor, this testimony has already been elicited.
Overruled.
True?
No.
Mr. Paxton did not summon you to his office to talk about this file?
Yes, he did.
He did not put pressure on you to either not rule against the requester or to release the information?
No, I would not classify it as pressure. The decision that we made was not.
Sir, I appreciate that. I'm not asking you what the decision was made. I was asking about your conversation with Mr. Paxton. He had one of two things that he wanted to occur. Either release the information or at a minimum, figure out a way not to rule against the requester. True?
Same objection, Your Honor, assuming facts not before this witness.
Sustained.
In your conversation with Ken Paxton about this particular DPS file, can you recall any other time when Mr. Paxton directly came to you and got involved on a DPS open records request?
No.
Ultimately, you did exactly what Mr. Paxton wanted, correct? You did not rule against the requester, Nate Paul's attorney, true?
Again, objection, Your Honor, assuming facts not before this witness.
Overruled.
True?
I'm sorry, could you repeat the question?
Yes, sir. Ultimately, the opinion was not to rule against the requester, which was exactly what Ken Paxton was pressuring you to do, correct?
Again, Your Honor, I'm going to object. She's now mischaracterizing this witness's testimony. He said he was not pressured.
Sustained.
By not ruling, you were not ruling against the requester. By making a no decision, that's not ruling against the requester, true?
That's correct. We didn't rule against either party, the requester or the governmental bodies at issue.
Now, earlier you said that the OAG decision not ruling against Nate Paul's attorney, quote, tilted the scale in terms of how a court would ultimately decide whether or not to rule on the disclosure of that information. True?
No, if I said that, I may have misspoken. We did not want to tilt the scale. We didn't want to tip the scale either way. We wanted to maintain the status quo and allow the court to review it completely de novo without our opinion, which is due great weight, tilting the scale based on the procedural requirements.
Withholding the information would have been detrimental to the requester. That's what you said on direct. Do you remember that?
I'm sorry, could you repeat the question?
You said withholding the requested information would have been detrimental to the requester. Do you recall that testimony?
I'm going to object, Your Honor. I don't recall that testimony either, so mischaracterization of his testimony.
And I'm happy to put her on the stand. I'm asking the witness if he recalls his testimony.
We can check with the court reporter.
I have a quote, it would have been detrimental to the requester.
Okay. I'm going to overrule. You can answer yes or no.
Yes, it would have concluded that the information could be withheld.
Now, on June 8th, after the opinion came out, Joanna Ward, do you know who that is?
John Ward?
Yes, sir.
Yes.
Okay. On June 8th, she was asking if you still had the file in your possession. Do you recall that?
Yes.
And the file she was referring to was the entire DPS file, correct?
Yes.
And within that file is one part of it would have been the probable cause affidavit that Nate Paul was looking for, correct?
No. I believe that, if I'm not mistaken, I think that was after the ruling had been issued.
It is, sir, but that's not my question. Included within the DPS file would have been the probable cause affidavit that Nate Paul was looking for, true?
No.
The probable cause affidavit would not have been within the DPS file.
Not after we issued the ruling, we would have sent the documents back to DPS.
But by June 8th, after the decision was released, do you recall Joanna Ward emailing you and specifically asking you if you still had it, it was still checked out to you, and asking when you were going to return it? Do you recall that?
Yes.
We talked a lot about precedent and what should be publicly disclosed. You would agree with me that a search warrant is treated substantially differently than a probable cause affidavit or search warrant affidavit in terms of whether or not that should be released to the public, correct?
There are different exceptions that can apply to those, but I would not characterize anything as what can or should be released to the public. It needs to have an exception that applies to it. But both can be released to the public. A search warrant affidavit is more likely to have an exception that applies. They're not automatically confidential.
Correct. No further questions, Your Honor.
Redirect.
Very briefly, in any of these requests, could either party have filed a lawsuit challenging the outcome?
Yes.
Did anyone file a lawsuit for the outcome of the FBI brief ruling request?
No.
That's all I have, Your Honor.
And just so the court knows, because it has been unusual, either side can ask questions from the podium or their tables in case anyone's asking. Can the witness?
Requires no redirect, Your Honor.
Pardon?
Witness requires no redirect. Recross.
Can the witness be excused?
Yes, Your Honor. Thank you, Mr. Gordon.
Am I released, Mr. President?
I'm checking with the House. Yes, you can be released. Thank you. Hence, we'll call their next. No, we're going to take a break. Sorry. We'll call your next witness after a break. How about 5 minutes after 10? 20-minute break? 11. Sorry. We passed the 10 hour. 5 minutes after 11.
All right, on break now till 11:05, and we'll take just a couple of minutes to talk to you about what that testimony was. It took a while to get there. They built up to it, but here it is. The documents that Nate Paul had, which were unredacted documents through Justin Gordon, we learned that it was actually not the Attorney General's office in filling his open records request, but that those documents came to his open records attorney, Jeff Larson, by the hand and way of the FBI. In cross-examination, Leah Graham, the prosecuting attorney that you're listening to now, in cross-examination, she said, weren't you summoned to Ken Paxton's office, and didn't he pressure you to give Nate Paul what he wanted or find a way not to deny his request? To which he said no. She finally asked, can you describe any other time where the Attorney General, where Ken Paxton, where he came to you with any concerns about an open records request, any other time? To which he answered no. And so that's where we are now as they take this break, and then they'll return with their next witness. Again, they are addressing the individual articles of impeachment. This goes to article number 3. They're trying to prove these secret documents, these documents that he should not have had, Nate Paul and his attorney, did not come from the Attorney General's office. That's what they're trying to prove in the minds of the jurors now. We'll take a break and then we'll see you back, okay? All right.
Impeachment trial of Texas Attorney General Ken Paxton is underway. Hello, I'm Steve Eager.
Hello, everybody. I'm Heather Hayes. The proceeding is political, not criminal, but it does pose the greatest threat so far to Paxton's career. Through his attorney, Paxton entered not guilty pleas to 16 articles of impeachment. The case centers on his relationship with real estate developer Nate Paul and whether Paxton abused the powers of his office to help Paul and to cover up his own wrongdoing. Fox 4's Sean Rabb in now with more on the trial coverage. Sean.
And the House managers in opening statement said the now suspended Attorney General used the office for his own benefit and should be removed. Paxton's attorneys called the charges untrue and incorrect. And now we also know Paxton cannot be forced to testify.
Our first order of business is to address 24 pre-trial motions.
And senators serving as jurors voted no to 16 defense motions to dismiss everything from articles of impeachment to certain evidence. In this political trial where the Attorney General is accused of misusing his power, abuse of office, fraud, and accepting bribes from friend and political donor Nate Paul.
This court notes that many factors and circumstances in this proceeding lean more on criminal in nature.
One early victory for Paxton, Lieutenant Governor Dan Patrick deciding that many of the rules in this impeachment proceeding lean towards the rules in criminal court, including whether the accused can be forced to testify.
And the House of Managers have repeatedly compared the actions of the House of Representatives to a grand jury. As they prefer the articles of impeachment, grand juries are utilized only in criminal cases. Therefore, the motion is granted. The Attorney General cannot be compelled to testify.
We never heard from Paxton during day one of proceedings. Standing between his attorneys as Tony Busby entered not guilty pleas to each article of impeachment.
Attorney General Paxton, how do you plead?
Stand by that report and therefore plead not guilty.
Your Honor, objection.
Busby's not guilty pleas with emphasis brought an objection from House Manager's attorney Rusty Hardin.
I ask that he just be instructed to plead not guilty or guilty, whichever he chooses, but not to be making speeches to his lawyer.
Sustained.
After lunch, Ken Paxton did not return to the chamber-turned-courtroom where House Manager Andrew Murr painted Paxton as using his office and power for personal gain. Murr arguing there's much voters don't know about Paxton's alleged misconduct when they reelected him.
Mr. Paxton has been entrusted with great power. Unfortunately, rather than rise to the occasion, he has revealed his true character. And as the overwhelming evidence will show, he is not fit to be the Attorney General for the state of Texas.
Busby, Paxton's lead attorney, told senators what was happening here was a whole lot of nothing, that Paxton did nothing wrong, and then turned his remarks pointedly to the senator jurors with a swipe at media reporting, much of it based on troves of documents published by the impeachment managers.
Have you already decided, based on what is politically expedient or what's best for you personally? Or is it even possible to get a fair hearing? Especially after this case has been tried in the press, Ken Paxton has been convicted in the press based on ignorance, innuendo, and outright lies.
Late this afternoon, the first witness took the stand, James Mateer, longtime second in command at the Attorney General's office, one of 8 who went to the FBI, but not one of the 4 whistleblowers. Through him, House managers and Attorney Rusty Hardin are starting to try and build this overly interesting relationship that Ken Paxton had in the affairs of Nate Paul. Testimony has concluded for today. Will begin tomorrow morning at 9 a.m.
Okay, Sean Rabb, I guess it's not like a criminal case. It is, but it's not. He doesn't have to testify, and those guys aren't jurors, the men and women in the Senate, so.
It's like a criminal case, has all the leanings of a criminal case, but won't have the criminal outcome if he is found guilty.
There's outside pressures, too, politically on all of them. All right, Sean Rabb, thanks.
All right.
Among the key moments during testimony in Ken Paxton's impeachment trial was the meeting a prosecution witness described where Paxton admitted having an affair.
So the witness, a former top aide in the Attorney General's office, said that explains some of Paxton's unusual behavior. But that witness testified the real cover-up happened when Paxton resumed the affair. And more details were revealed about what he and others told the FBI about Paxton's questionable dealings with an Austin businessman. Fox 4's Blake Hansen in studio tonight to take us through today's testimony. Blake.
As Stephen Heather, this was effectively the first full day of testimony, much of it centering around Paxton's former top deputies and what they witnessed on the job.
I was quite frankly sick of dealing with Nate Paul.
It was another one of Ken Paxton's former top deputies and whistleblowers taking the stand late Wednesday. Ryan Bangert talked of donating to Paxton's campaign before joining the office and being a fan of Paxton's work.
I believed in what he was doing. I believed his policies were the best for Texas. That's why I joined his office in 2019.
But Bangert says in 2020, Paxton began asking him to intervene in matters involving Paxton's friend and campaign donor, businessman Nate Paul. At the heart of prosecutors' case are accusations Paxton allowed Paul to use the AG's office to his benefit. Bangert says Paxton requested they intervene in an open records dispute, a dispute between Paul's businesses and a charity, and more.
Is that the third time you've now been asked within 6 months to review a matter that involved Nate Paul?
Yes, and yes.
Right. So at this time, how would you characterize your feelings about whether or not the AG's office ought to be getting involved in anything that involved Nate Paul?
My feelings were that I was becoming increasingly concerned.
Bangert described unusual behavior when Paxton asked them to rewrite an opinion about foreclosures to do the opposite of staff's suggestion.
It was bizarre.
And why was it bizarre?
He was acting like a man with a gun to his head.
In what way?
Anxious, desperate, urging me to get this out as quickly as humanly possible.
Bangert described taking off one of his staffers' signatures and adding his own to the opinion for fear it would tarnish the young man's career.
I changed it to go out under my signature.
And why?
At the end of the process, I had become very alarmed by the Attorney General's behavior. I had promoted Ryan Vassar into that position myself, and I felt a degree of responsibility to him.
Before Bangert, we heard from former First Assistant Attorney General Jeff Mateer. He recalled in September 2020 how Paxton and his wife, State Senator Angela Paxton, called an emotional meeting with senior staff.
Mr. Paxton revealed that he had been engaged in an extramarital affair and asked for our forgiveness.
But then Mateer says he learned the affair had resumed. He and others alleging Paul manipulated Paxton for favors to help cover it up. On cross-examination, Paxton attorney Tony Busby and Mateer were heated at times. Busby sought to downplay Paul's influence over Paxton.
In 2018, what percentage Nate Paul's campaign contribution was with regard to the total amount raised by Ken Paxton? Well, if your math is correct on this demonstrative, it's there, but I wouldn't have known that then, no. 0.37%.
Busby also directed questions about who knew what, when, about reporting Paxton to the FBI.
You were involved in staging a coup, weren't you? Absolutely not. You were staging a coup, weren't you? Absolutely not.
The prosecution is not yet done with its questioning of Bangert, and he has yet to face cross-examination from the defense as well. Stephen Heather.
All right, Blake, likely see you tomorrow and maybe the rest of the week. Thank you very much. There was dramatic and at times contentious testimony today at Ken Paxton's political trial in the Texas Senate. We also saw emotional moments from Paxton's former employees who went to the FBI complaining that their boss was allowing the Attorney General's office to be misused by a political friend. Fox 4 Sean Rabb, watching today's testimony, is here with the highlights again. Sean?
Steve, another whistleblower in the Attorney General's office who did not file a lawsuit said he felt the AG's office had been hijacked to help developer and Paxton donor Nate Paul. And Ryan Bangert testified the group of 8 who went to the FBI were not staging a coup, but wholly concerned.
Did you consider it a mutiny?
It was not a mutiny.
How would you characterize it?
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
That's how Ryan Bangert testified about going with others to the FBI, concerned about the relationship between Attorney General Ken Paxton and real estate developer, Republican donor Nate Paul. That assertion, though, challenged under, at times, combative cross-examination by Paxton attorney Anthony Oso Jr., with Lieutenant Governor Dan Patrick instructing the witness to answer.
Now, at no point after you reported to law enforcement were you terminated from your position. It's a yes or no question, Mr. Bangert. Were you fired or were you not fired?
I was constructively discharged.
Now, I asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively discharged.
Bangert testified Paxton took him to a lunch meeting with Nate Paul, who complained about being treated unfairly and wanting the AG's office to intervene in his financial dispute with a nonprofit foundation that invested millions in some of his Austin projects.
What was your impression about that, what that whole meeting was about?
The strong impression that I had developed was I had been summoned to that lunch by Nate Paul to hear out his grievances and to convince me to get on board with the Mitty Foundation intervention program.
All of this happening while the AG's office was wrestling with much bigger issues, from a Google lawsuit and COVID.
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
One of those issues, COVID-related. A midnight order in August 2020 restricting to 10 the number of people attending outdoor foreclosure sales pushed for by Paxton. Bangert said he was against it, later learning Nate Paul benefited because he had multiple properties in foreclosure.
The Attorney General was determined to harness the power of our office and to fulfill the interests of a single individual against the interest of the state.
Under cross-exam, this hard line of questioning.
You're here to testify in the court of impeachment. Do you not remember the day that you went behind Ken Paxton back to the FBI? Do you not remember that?
Sir, we did not go behind the Attorney General's back.
Did you tell him you were going to the FBI? Yes or no?
Sir, we did not go behind the...
Mr. Bangert, I'm asking you yes or no questions. Did you tell Ken Paxton that you were going to go to the FBI?
On September 30th, we did not.
It's a yes or no question, Mr. Bangert.
It's not a yes or no.
It is a
question.
yes or no.
The mood in the chamber turned courtroom changed as witness Ryan Vassar, former Deputy Attorney General for Legal Counsel, tried to hold his emotions as he talked about being called rogue by his boss, Ken Paxton.
And it's contrary, the statement of being rogue is contrary to the years that I dedicated my life to the state.
U.S. Senator John Cornyn, on a call with Texas media today, called the impeachment trial very deeply disturbing and painful to watch. Continues tomorrow.
All right, Sean, thank you very much. We'll see you soon. As we continue to cover the impeachment trial, you can watch the live stream on fox4news.com, the Fox 4 YouTube page, and when we're not in a newscast, on Fox Local. That's our streaming app on Apple TV, Roku, Android, and Amazon Fire. It's free to download, and there is no login required. Whistleblower text messages and former Texas Rangers testimony dominated day 4 of suspended Attorney General Ken Paxton's impeachment trial. Paxton was again not present in the courtroom where his attorneys attempted to tear down previous testimony. Fox 4 Sean Rabb in studio with more. Sean.
And Steve, those whistleblower text messages in a group chat days after going to the FBI about Paxton. That former Texas Ranger who was over the AG's law enforcement division compared Nate Paul, the developer and Paxton donor at the heart of this political trial, with Billy Saul Estes. He was convicted of perhaps the most sprawling fraud scheme in history.
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
Former Texas Ranger David Maxwell, who was the Attorney General's law enforcement director, testified what he told Ken Paxton about Nate Paul after his first meeting with Paul, a meeting he was told to have by Jeff Mateer, who testified Tuesday. Maxwell had 2 meetings with Paul and his attorneys that were recorded, and a third meeting that included Paxton, not recorded at Paxton's insistence. Paul, Maxwell said, was angry, pressing for the AG's office to investigate DPS troopers, FBI agents, and a federal judge in connection with search warrants at his businesses and home.
And I told him that all you're doing is using the power and the prestige of this office for your own purpose, and I'm not going to allow that.
Maxwell says after that meeting, Paxton never spoke to him again. 2 months later, he was placed on leave. A month after that, he was fired.
You are insulting your colleagues on this group chat among friends. True?
I wouldn't describe it as insulting.
Text talk between the whistleblowers after they went to the FBI, also part of Day 4 testimony. Joking about Ken Paxton and other staff in the AG's office not being smart. Ryan Vassar, who testified through tears Thursday at being called a rogue employee, posting a link in the chat to a coloring book, suggesting new staff needed something to entertain them.
It was a joke.
I believe earlier your testimony was that being called a rogue employee was very upsetting to you, right?
Yes, sir.
But this is how you talk about your coworkers. True?
Again, it was lighthearted. It was among friends. It was not made public to millions of people.
Lawyer Little tearing at previous testimony that Nate Paul's issues overwhelmed the Attorney General's office.
How many lawyers are there roughly at the Office of the Attorney General?
Roughly 800 lawyers.
How many of them ever touched anything related to Nate Paul? How many of the 800 ever touched anything related to Nate Paul?
I could speculate there may have been 15 lawyers, maybe 15 to 20.
With 20,000 active cases at any given time.
And how many of those 20,000 cases involve Nate Paul?
I would have no direct knowledge of how many of those cases would.
The cross moving to the so-called August 2nd midnight order that restricted the number attending foreclosure sales. Nate Paul had 13 properties set to be sold August 4th, 2020. Little pressed on whether it was just one of many COVID guidances being released almost daily.
Orders similar to this that were giving informal legal guidance about COVID matters were coming out of your office almost every day. True?
I'm not sure if it was daily, but we were providing advice on a regular basis.
Now, each side has been given a total of 27 hours to present their case, and we are more or less halfway through that allotted time. Testimonies ended for now, resumes Monday at 9 a.m.
Day 5 of suspended Attorney General Ken Paxton's impeachment trial is marked by a whistleblower testifying that Paxton's friend and campaign donor acted like he was the real boss of the AG's office.
The witness said he warned that Paxton could put himself in legal jeopardy by helping Nate Paul, and that Paxton expressed a personal grudge against law enforcement. Fox 4's Sean Rabb joining us in studio with more of today's testimony. Sean.
Yes, former deputy over criminal justice spent about 4 hours testifying about phone calls and meetings with the Attorney General around Nate Paul, who is the subject at the center of this impeachment trial with Ken Paxton. In a meeting with Paxton and Paul, Mark Penley informed the office would not investigate his claims any further, and that, he testified, brought an angry response from Mr. Paul.
Mr. Paul acted like we didn't understand who the real boss was. It wasn't the Attorney General, it was him. That was his body language, that was the expression on his face, the way he bowed up. He got very unhappy with us.
Nate Paul wanted the Attorney General's office to look into his allegation that laws were broken during the search of his businesses and home by state and federal authorities. Paul wanted the AG's office to investigate troopers, FBI agents, an assistant U.S. attorney, and a federal judge. Mark Penley said he and former AG Law Enforcement Director David Maxwell, who testified Friday, decided to slow walk the investigation, hoping Paxton would drop it because he thought it was crazy.
Why did you think it was crazy?
The idea that the state of Texas Attorney General's office would go investigate the federal courthouse, investigate federal agents and also state agents that were task force officers on the raid, and those were agents from the DPS and the State Securities Board, that we would investigate a federal magistrate judge and federal prosecutors was insane.
Penley, a former deputy in the AG's office, testified in phone calls and meetings Paxton kept pushing for Paul's claims to be investigated.
I asked him why he was so interested in this investigation when he was not interested in all the other criminal investigations and cases we had pending in the office.
All right. And what was his response?
His response was, I don't know about the other cases, but I know about this one, and I'm concerned about corrupt law enforcement because of what's happened to me.
That in reference to Paxton's 2015 indictment on securities fraud charges, still pending to this day. Penley told the court he met the Attorney General at Paxton's request at a Dunkin' Donuts in McKinney, September 26, 2020. That's when he learned Paxton had contracted Brandon Kamak as outside counsel, another extraordinary move to push forward Nate Paul's claims.
How was the tone of this conversation?
He was frustrated, and that was the most, it wasn't a hostile conversation, but it was a difficult conversation.
How did the conversation end?
I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it.
On cross-exam, Paxton attorney J. Mitchell Little focused on Penley and Maxwell, quote, slow-walking the investigation.
And Ken Paxton was upset with you that in 6 weeks, you and David Maxwell had done nothing. True?
Which part of the question do you want me to answer first? You asked me if we'd had it for 6 weeks. That is true. And it's also true we had done no investigating in that 6 weeks.
Challenging what proof Penley had that Paxton had done anything wrong.
On September 26, did you have any physical evidence, documentary evidence, eyewitness evidence, or circumstantial evidence that Ken Paxton had committed or been bribed by Nate Paul?
I had circumstantial evidence.
Anything else?
I had his behavior.
Anything else?
The campaign donation.
Anything else?
His absolute refusal to listen to common sense and reasoned legal positions. He wouldn't listen to anybody on the executive staff.
There was another staffer this afternoon testifying about the Paxton affair and the impact of the morale on the Attorney General's office. Now, this morning, Lieutenant Governor Dan Patrick says testimony could end Thursday. Each side will then get 1 hour for closing statements. Senators will have to stay in Austin and deliberate through the weekend if necessary until they come to a decision.
Okay, Sean, thank you.
All right.
You can watch the trial. It's streaming live on fox4news.com, the Fox 4 YouTube and Facebook pages. And when we're not in a newscast like we are at this moment, it's available on Fox Local. That's our streaming channel on Apple TV, Roku, and Amazon Fire. It's free to download, and no login is required.
Well, today, the Texas Senate heard testimony from the man Ken Paxton turned to when his own staff would not do his bidding.
Brandon Kamak served as special prosecutor, reporting to the now suspended Attorney General and digging into the criminal investigation against Paxton's political donor friend, Nate Paul. This is day 6 of testimony at Paxton's impeachment trial. Sean Rabb in studio again today with more on the testimony today. Sean.
All about Brandon Kamak. He was 5 years out of law school, never a prosecutor, had only 15 to 20 jury trials under his belt when on his cell phone on his birthday, Attorney General Ken Paxton. From August 2020 moving forward. He testified some point in September of that year. Paxton wanted him to communicate with him through something called Signal app, an encrypted communication, and that he did everything at the direction of Paxton over 6 weeks that would change his life.
Who in the Attorney General's office in a position of responsibility did you consistently have your contact with?
The only person I reported to was Mr. Paxton at his
You need me to move? You're good. Okay. We're good there? Okay.
Please call the next witness. Who will that be?
Thank you, Your Honor. Chris Hilton for the Attorney General. The next witness is Austin Kinghorn.
Bailiff, please bring in Mr. Kinghorn.
And Your Honor, I'd just like to, while Mr. Kinghorn's coming in, I just want to clarify for the record, for the jury, and for the public. At the end of the day yesterday, we had called Professor Michael Gerhardt, who's intended to be one of our expert witnesses. Last night, the court ruled that the expert testimony we were going to provide would not be heard. And so to the extent there was confusion, I just want to make the jurors aware and the public aware that that was the court's ruling, and that's why those witnesses aren't here.
And the court ruling was based on objection from the House under rule such and such.
Yeah, yes.
And we took about an hour to deliberate and look at all the questions.
That's right. I apologize for, yeah.
We ruled in favor of the House on that.
Just wanted the public to be aware, that's right.
And you were very kind to pull them from your witness list.
Dr. Michael Gerhardt, professor of School of Law at University of North Carolina, recognized as an impeachment expert, was scheduled to be the first
Mr. Kinghorn,
witness.
I believe, already swore you in
Respondent
the
Paxton.
group. You may be seated. Speak loudly and closely to the mic. Thank you.
But last night determined his testimony would not be admitted.
Austin, good morning. Thank you for being here. We both need to speak slowly and loudly into the microphone, I am told. You've testified in this chamber before the Senate, correct?
Yes, I have.
Okay, so you know the acoustics in here can get a bit weird, especially for our folks in the back.
That's correct.
So please just introduce yourself to the jury and tell us about your career.
My name is Austin Kinghorn. I'm the Associate Deputy Attorney General for Legal Counsel at the Office of the Attorney General. Would you like me to go back from the
Yeah, sure. Why don't, if you could please just start with law school, walk us through what you've done up to the present day.
So I graduated from Baylor Law School in 2010. After that, I did a clerkship on the 14th Court of Appeals for then Justice Jeff Brown. I did a stint in commercial litigation. Yes, sir. I did a stint in commercial litigation after that, primarily doing insurance defense. After that, I went to work for the AG's office in the Civil Medicaid Fraud Division. When Justice Brown was elevated to the Texas Supreme Court, I went to work for him again as a staff attorney. I worked at the court for about 6.5 years in that capacity for Justices Brown and later Justice Jane Bland, and then came back to the AG's office in the General Counsel Division. From there, I was promoted to General Counsel, and then most recently to the title that I hold now.
Thank you, sir. And tell us a little bit about your work for the Attorney General and your current roles, both as General Counsel, Opinions Committee, and your current title.
Right. So as the Associate Deputy for Legal Counsel, I'm over 2 divisions. It's a General Counsel Division and the Opinion Committee. In that role, I am both the Division Chief of General Counsel and General Counsel for the agency, and also Chair of the Opinion Committee.
How many employees do you oversee?
19.
And are you proud of your time at the Attorney General's office?
I am very proud.
I think this is a bit of a silly question, but it's come up a lot. Are you a rhino? Do you know what a rhino is?
Yes, I do. I've been called a lot of 4-letter words. That's not one of them.
What are your politics? Are you conservative?
Yes, I am.
Again, I think it's a silly question, but it's being asked. On a scale of 1 to 10, how conservative do you think you are?
11.
Fair enough. What I'd like to do today with you is go through these articles of impeachment, see if there's any perspective you can provide as to each, and I appreciate you being here helping explain the work of the agency for the jury. So let's start with Article 1, which relates to the Mitty Foundation and the intervention into that lawsuit. Were you directly involved in that lawsuit or that intervention in any way?
I was not.
Okay. But are you familiar with EAMs?
Yes, I am.
Unfortunately, we've talked a lot about EAMs during this trial. What's your understanding? What is an EAM to you?
An executive approval memorandum is a document that the agency relies on to seek and attain executive approval of various agency actions or engagements.
And do you receive EAMs as part of your work?
I do. I probably receive 1 or more a day.
What do you do if you have concerns about an EAM?
If I have concerns about an EAM, typically the practice is going to be to reach out to who circulated the EAM and, engage with that person directly, try to flesh out the issues. Sometimes it's simply a matter of correcting something in the EAM and recirculating it. So, the first step is always just get in touch with the folks who are asking for the executive action and connect and make sure you have an understanding of what's going on.
If you get an EAM that you're concerned about or you're proposed a course of action that you don't agree with, do you just go ahead and sign the EAM anyway?
No, I do not.
Okay. So what does signing the EAM signify?
That would signify that you have reviewed the EAM, you reviewed the legal authority in it, the explanation of the rationale for the action that's being sought, and that you approve of that action being taken.
So if someone at the Attorney General's office signs an EAM, does that mean they've approved that action?
That's correct.
What about, let me ask you this, does the Attorney General have to have an EAM that's fully approved by his subordinates before he takes an action?
No, he does not.
Why not?
The Attorney General's authority and the First Assistance Authority flow directly from the Texas Constitution and from statutes, specifically Government Code Chapter 402. The EAM process exists to vet certain proposals, but it is ultimately not binding on the person or persons who actually possess the constitutional executive power to act as Attorney General or on behalf of the Office of the Attorney General.
So just to make that clear, the Attorney General has the legal authority to act without an EAM approved by his subordinates?
Absolutely.
Okay. Does that include the authority to sign a contract?
Yes, it would.
Okay. Let's look at an example of an EAM. Can we pull up House Exhibit 62, please, Mr. Arroyo? Your Honor, I believe this has already been admitted into evidence. and I'm going to try and go electronic today, so we'll see if it works. And Mr. Arroyo, if you could just zoom in on the signatures on the top of this EAM and maybe capture the subject line as well. Have you seen this EAM before, Mr. Kinghorn?
Yes, I have.
Okay. And which EAM is this?
This is a EAM requesting approval to intervene in the Mitty Foundation litigation.
You weren't a signatory on this EAM, correct?
No, I was not.
Okay. But let's look at the first signatory. That's Mary Henderson. Who is that?
Mary Henderson at the time was in our financial litigation division, and she held a senior attorney role in that division.
And what does her signature on this EAM indicate?
That would indicate that she has approved of the action described in this EAM, and it looks like she's the one who actually circulated this EAM.
Why do you say she's the one who circulated it?
It says from Mary Henderson, and also she's the first signatory. So typically the first signatory on the document, the lowest signatory would be the person who actually routed the document for approval.
So does this indicate that Mary Henderson and Kat Day actually authored this EAM? Is that what this says to you?
That's likely the case, yeah.
Do you know whether the Attorney General ever spoke with Mary Henderson or Kat Day about this EAM?
I do not know.
Okay. Who's next on the signature line? Who's Josh Godby?
Josh Godby at the time was the division chief for the financial litigation division.
And what does his signature here indicate?
That would also indicate approval of the action that the EAM is seeking.
And who's next up the chain on this EAM?
It's Darren McCarty.
What was his role at this time?
At the time, he was the Deputy Attorney General for Civil Litigation, so you'd see his name a lot on EAMs like this involving requested courses of action in active litigation.
And again, I want to be clear about what his signature means here. When he docu-signed this EAM, what does that indicate to you as General Counsel of the agency?
That indicates approval of the action that is sought by the EAM.
And same question with Mr. Mateer. What was his role and what does his signature here indicate to you?
Jeff Mateer was the first Assistant Attorney General at the time, and his signature would indicate approval of the action that EAM seeks.
And would it be your expectation that all of these people who signed this EAM have read it?
It would. I mean, that is certainly the point.
That's what you normally do within OAG, right?
Correct.
And would it be your expectation that they understood the memorandum before they signed it?
I would not sign an EAM that I did not
Objection,
fully
Your Honor.
understand.
Question calls for speculation.
I'll move on. Thank you, Mr. Roy.
Sustained. And
all right, let's move on to talking about Article 2. That's about the foreclosure guidance letter. It's been called a lot of things in this courtroom. That's what I'm going to call it. Do you understand what I'm referring to? Are you familiar with that letter?
I do understand and I am familiar with it.
Okay. Did you work on that guidance letter personally?
In a very limited capacity early on, I performed some very perfunctory research on it. I never participated in the drafting of the letter itself.
Okay. Who asked you to do that research?
Ryan Vassar.
And did you form a conclusion as to what was the ultimate outcome in your limited role?
As memory serves, I didn't form any firm conclusions at the time. I performed a couple hours, maybe 3 hours of research, and really just had enough time to kind of come up with some general parameters of what the issues were. And Mr. Vassar and I had a phone conversation about what we had found so far in our respective research, and he took it from there, and I never had another conversation with anyone else about the letter moving forward.
Did you see the letter once it was ultimately issued?
Only when it was issued, yeah, when it went up on the website.
Right, so to be clear, you weren't involved in the drafting process, so you don't know how they got from A to Z on that.
That's right.
Okay, but you saw the final letter.
I did.
Did you agree with the analysis and the conclusion in that letter?
I do.
Objection, Your Honor. Relevance.
overruled.
And just as sitting there, as you sit there today, can you briefly explain what that letter does in your view? Well, or rather, let me rephrase. Can you explain the conclusion of the letter?
The legal conclusion?
Yes.
The legal conclusion essentially was that under the circumstances of COVID at the time, with 10-person restrictions on in-person gatherings, that there was a possibility that a public sale, as defined by statute, that necessary element to proceed on a foreclosure wouldn't be satisfied if you didn't have a situation where anyone who wanted to be a bidder on a property that was under foreclosure would have an opportunity to bid on it and thus get the best, most fair value for the property.
Let me make sure I understand each piece of that. So you mentioned the public sale issue. That's a requirement out of statute. Did I understand you?
That's right.
Okay. And you mentioned a bidder being excluded. Why would that be the case?
Sorry, could you repeat that?
I thought you mentioned that the 10-person requirement might result in a bidder not being able to participate in a foreclosure sale. Why would that be the case?
Correct. So normally these sales are open to the public. Anyone who wants to go bid on a property can, and that of course has the effect of increasing the price, typically. And the COVID restrictions at the time, the governor's executive orders only permitted 10 people to gather at once in what was considering, I think the nomenclature was at the time, a public gathering.
So to make sure I understand what you're saying, if there were bidders that were excluded, that could drive the price down at the sale?
Yeah, that's certainly a possibility.
Okay. In your view, does that letter shut down foreclosure sales in the state of Texas?
I don't have an opinion on whether it did or didn't. I do know it was non-binding and informal legal guidance.
Did you work on any other COVID-related opinions or guidance documents?
I worked on a great number of them. During my first several months at the agency, starting in June of 2020, COVID-related work was the vast majority of what I was doing.
And if you could just briefly for a minute here, explain to the jury, explain to the public, we're trying to explain the work of the Office of the Attorney General today, so explain what it was like to be working on these issues during COVID.
It was intense. It was a demanding time, as I'm sure it was for a lot of people in this room. We were on the cutting edge of a lot of novel legal issues. A lot of folks were looking to the AG's office for guidance and direction on how to respond, how to navigate the challenges that were coming forward, especially as it pertained to the governor's executive orders, which were coming out. We were often looked to for guidance on how to comply with those, what they meant construing them, and we fielded those requests from all corners.
Was it unusual during that time to have expedited requests or to be working on short deadlines?
That is never unusual at the OAG, under any circumstances.
Particularly so during COVID?
Sure, particularly so. Everyone who came to us with a problem needed an answer and wanted an answer, at least quickly.
Understood. Let's talk about opinions and guidance documents from the Attorney General's office more broadly. What kinds of guidance can the Attorney General issue?
Well, there's a range of options. A lot of folks in this room are probably familiar with our formal legal opinions. Under Chapter 402 of the Government Code, an authorized statutory requester may request a formal legal opinion from the OAG, and that opinion, while not binding, is a source of persuasive legal authority that courts typically will look to and consider when resolving a case. But we have other tools in our belt beyond that. Additionally, under Chapter...
Before we go to the next one, I just want to clarify one thing. You mentioned that a lot of folks in this room might be familiar with that formal legal opinion. Why would that be the case? Why would these senators and some of these House members be familiar with that?
Chairs of legislative committees, senators and House members, are authorized requesters under the statute.
Okay. Does the Attorney General's office work frequently with those authorized requesters regarding their requests for opinions?
We frequently work with members of the legislature on a host of issues and try to be as solicitous as possible in being helpful and giving the best legal guidance we can.
And I'm sorry I interrupted you. So that was the formal legal opinion process. You're moving on to the next category, so I apologize for interrupting.
Sure. So under Chapter 418 of the Government Code, which is the Texas Disaster Act, the AG's office has additional authority to provide legal counsel to local political subdivisions during a declared disaster. Authorized requesters include mayors, county judges, county commissioners, emergency management directors. Beyond that, the office has historically operated with the understanding that we have broad legal authority with the Attorney General as the chief legal officer of the state to issue informal guidance of public note, of public interest that would have a wide applicability to the public at large, especially in disaster situations where there's a need to get good information out to the public on pressing issues. And that authority, I think, flows directly from the Attorney General's constitutional and statutory authority as the Attorney General, as the chief legal officer of the state.
Other than the foreclosure guidance letter, can you recall any examples of other COVID-related guidance that was issued that also fell in that third category you described?
We put several guidance documents out on issues that a lot of folks are facing. Churches, private religious schools. I know that we did some opinions on access to vacation homes, and not opinions, letters on access to vacation homes in other states, where golf courses fell in terms of the governor's orders for shutdown purposes. So there were a lot of topics that we put something out there short of a formal opinion that was designed to provide generally applicable informal legal guidance to the public at large.
So it's fair to say, is it fair to say that the foreclosure letter was not unique in that regard? It was not the only informal guidance that was put out?
That's correct.
Let's look at a couple of other examples of guidance from this time. Mr. Arroyo, if you could pull up House Exhibit 105. And I believe this has already been admitted, Your Honor. Are you familiar with this document, Mr. Kinghorn?
Yes, I am.
And just very briefly, what is this document?
Objection, Mr. President. This document is not in evidence.
I apologize. I thought it had been admitted. It's House Manager's Exhibit 105, and I'd offer it if it hasn't been admitted.
We thought it was pre-admitted, Ms. Epley?
No, Mr. President, I don't believe so. We don't object. It's our document to begin with. I just wanted to make sure the record was clear.
Yeah, I apologize. I tried to get this smoothed out with counsel before we started, but yes, I offer it, if it hasn't already been admitted.
Okay. It will now be admitted into evidence. That's exhibit, what's the number, 105?
House Exhibit 105, Your Honor.
Okay. Admit it to evidence.
Mr. Kinghorn, if you could, please just, to the extent that you can, please just describe briefly what this document is.
This was a general guidance document that the agency issued to houses of worship during the COVID pandemic.
Is this a full-blown opinion under Chapter 402?
It is not.
And is this a disaster council letter under Chapter 418?
No, this is not.
Mr. Arroyo, if you could show us the bottom of the page, there's a date next to the exhibit stamp. And when was this letter issued?
It says April 27th of 2020.
Do you think it was any way improper for the agency to issue this guidance?
No, I do not. And in fact, I think this is the kind of guidance a lot of folks were looking to the Attorney General to provide.
Let's look at another example.
May I seek clarification? He was confirming that the guidance in regards to the House of Worship, Exhibit 105, is not something he takes issue with, correct? Not the foreclosure letter itself?
Your Honor, she can cross-examine the witness to clarify.
I'm clarifying.
This is my examination, and she should be able to.
You can cross-examine on that.
Okay, thank you.
Thank you, Your Honor. Let's briefly look at House Exhibit 104 next. I also thought this one had been pre-admitted. Maybe I'm wrong. To the extent that it wasn't, I'd offer House Exhibit 104.
Thumbs up.
Mr. Kinghorn, have you seen this letter? Or rather, are you familiar with this letter?
Yes, generally speaking, yes.
Okay. This is a letter in response to Chairman Frank?
Yes, this is the one about the golf courses. Okay, I had to read a little bit into it.
Okay, great. Let's look at the last page, please, Mr. Arroyo. If you could just zoom in on that text, please. So this letter, was this a full-blown Chapter 402 opinion?
No, it was not.
And how can you tell that?
It's got some language there caveating that it is not a formal opinion issued pursuant to section 402.042, which is our formal opinion statute.
It says on the letter that it is not a formal opinion under Chapter 402.
That's right.
So if someone were to say that this was a Chapter 402 opinion, they would be wrong. Do you agree?
I do.
Are you aware that the foreclosure guidance letter has substantially similar language in it?
Yes, I am aware of that.
Okay. And who was this letter signed by?
Ryan Vassar.
So Ryan Vassar signed an informal guidance letter.
Yes.
Does that indicate to you whether Mr. Vassar thought he had the authority to sign that letter? Do you think there was an issue with authority for issuing this letter?
I assume that he operated under authority to issue this letter on behalf of the agency.
Did you think a requester was necessary for the foreclosure letter?
No, I did not, personally.
Do you have any personal knowledge as to why one was sought?
I do not.
So you'd have no reason to disagree with me if I were to tell you that a requester was demanded because someone was trying to get out of doing the work.
Objection, Mr. President, I'm sorry. Counselors testifying to facts not known to this witness.
Sustained.
You can take that down, Mr. Royal. I think that's enough for Article 2. I think we're going to skip Articles 3 and 4 because I don't think you have any unique responsibility with regard to the PIA. Is that true?
I do not, that's right.
And we've heard plenty about the PIA today. But as an aside, does the Attorney General have the authority to access any case file or file in the agency?
Yes, I believe he does. He's the Attorney General.
Why does that give him the right to access any file he wants?
Well, I guess there's kind of an old saying in the legal profession that his name's on the wall. It's his agency, and he's the duly elected Attorney General. So it's his law firm. He gets to see a file if he wants to see it.
So if someone were to say that the Attorney General improperly accessed a file, would that make sense to you?
That would not compute to me.
Me neither. Can we pull up Article 4 briefly, Mr. Arroyo? Do you see the allegation here where it says Paxton improperly obtained access to information held by his office? Did I read that correctly?
Yes.
Let's go to Article 5 now. Take that down, Mr. Royal. Are you familiar with the contract with Brandon Kamek?
I am.
Okay. Did you have any involvement with hiring him?
I did not.
Did you have any involvement with drafting the contract or executing it or anything like that on the front end?
I did not.
Okay. When did your involvement with this particular contract begin? When did your familiarity with it begin?
sometime later, after the contract had been terminated, I believe Mr. Kamek reached out to our office to inquire about payment on the contract for the outstanding invoices.
And when you say reached out to our office, does that mean he reached out to you as general counsel, someone in your division? Do you recall?
My best recollection is that it was a phone call to the general counsel division. I think he was looking for someone to talk to about it.
Do you remember a date for that phone call?
I don't.
Was that before or after you'd been promoted to general counsel?
I believe it was after.
Okay. And when were you promoted to general counsel?
During the month of November of 2020.
Okay. So sometime after your promotion in November 2020, Mr. Kamek called to inquire about payment on his contract. Is that your testimony? I just want to make sure I understand the timeline.
That's right.
Okay. You were made aware of this phone call. What did you do with that information?
I conferred with Leslie French, our chief of staff, on that, primarily because she had more awareness of these issues and what had been happening at the time. As I said before, I had no involvement with the contract. So she and I recall discussing it.
Objection, Mr. President. Question calls for hearsay, or he's about to get into hearsay at this point.
And let me clarify. Please don't...
Sustained.
Yeah, thank you. Of course, I agree. Please don't relay the contents of any conversation that you have with anyone else. Don't tell me what anyone said. Again, I'm just asking, once you became aware of this request for payment, what happened next? So you said you conferred with Leslie French. Please pick up there.
My best recollection on this is that at some point, a call was made to Mr. Kamek.
Objection. Anything you could state after that is going to be hearsay.
We don't know what he's going to state next, so I don't think that's true.
Overruled.
In that case, anything next is non-responsive. May he ask another question?
You can break it down into questions.
Did you reach out to Mr. Kamek?
Yes.
What was the purpose of reaching out to Mr. Kamek?
To follow up on his inquiry.
What did you want Mr. Kamek to know when you followed up with him?
Objection, Your Honor. Hearsay.
I didn't ask for what he said. I asked for what he wanted Mr. Kamek to know in response to his inquiry.
Overruled.
The purpose of the call was to inform Mr. Kamek of how he might proceed about processing his invoices under the contract.
And what were Mr. Kamek's options to get paid at that point?
There remained work within the scope of services that had not been satisfied before we could issue payment. Specifically, the preparation of a report of his findings hadn't been completed. So what I relayed to him, and I believe this was over a voicemail, was that we couldn't make payment on the contract until that commitment had been made.
If Mr. Kamek had sent you that memo that he had contracted to provide, what would you have done?
Subject to any other clerical reason that we might have to shore up, from my view, it was a payable invoice because it was a valid contract at the time that the services were performed.
Did you ever hear back from Mr. Kamek after you advised him that if he sent you the memo, he could get paid?
I did not.
Mr. Kamek never called you?
Not to my knowledge.
And again, when was this, to the best of your recollection?
My best recollection is it would have been sometime in November or later.
Let's go ahead and skip ahead to Article 7, just briefly. Are you aware of the Attorney General's Office internal report regarding the events underlying this impeachment proceeding?
Yes.
And broadly speaking, what is that report as you understand it?
That report is the findings of a 10-month investigation that was conducted internally at the Office of the Attorney General concerning the allegations that the whistleblowers raised.
Did you ever review that report?
I did.
How many times? What was the nature of your review?
2, no more than 3 times, I was provided a copy and asked for general feedback on the document, proposed edits, revisions, things along those lines.
Were you ever directed by anyone to make sure that the report was a sham?
No.
Were you ever directed to make sure it included false or misleading statements?
Absolutely not.
Are you aware of anyone else receiving such a direction?
Absolutely not.
What would you have done if you had identified a false or misleading statement in that report when you reviewed it?
If I had identified a false and or misleading statement, I would have immediately raised that issue to the folks who are working on the report for consideration.
When was that report published?
That was August 24th, I believe, of 21.
And just to be clear, I'm looking at the text of Article 7 here. The allegation is Paxton directed employees of his office to conduct a sham investigation. Are you aware of that occurring?
I'm not aware that that occurred.
And you're one of the employees who, at least to some degree, worked on the report?
That's right.
The report was published in August 2021, you said?
That's right.
And it's been on the has it been on the Attorney General's office website continuously since that time?
Yes, it has.
So, was that before or after November 8th, 2022, that this report was issued to the public?
After. Can you repeat the question?
Sorry. Was the report made public before or after the Attorney General's election on November 8th, 2022?
Oh, I'm sorry, before.
It's been on the Attorney General's office website continuously since then.
That's right.
Are you aware of whether there was reporting on the issuance of that report?
There's been extensive reporting on the issues that were discussed in that report.
When did that reporting begin, as far as you're aware?
That reporting began pretty much immediately when the whistleblowers reported General Paxton as law enforcement, and it's something we've been dealing with ever since.
And the OAG report also contains the details of those facts?
It does.
And that's been public?
Yes.
On the Attorney General's website?
Yes.
You can take that down, Mr. Roy. Let's move on to discussing Article 8 a little bit. Article 8 deals with the settlement of the Brickman versus Office of Attorney General litigation. Are you generally aware of that litigation and that settlement?
Yes, I am.
As part of the agreed settlement terms in that case, are there any contingencies that must be satisfied before the settlement is fully effective?
Well, the biggest contingency would be funding for the settlement itself. I think there may have been some non-monetary considerations as well, but I think maybe the one you're asking about is the contingency of the legislature funding the requested amount.
That is the one I'm asking about. Why is that legislative appropriation of funding contingency necessary for this settlement?
Like other state agencies, the Office of the Attorney General is prohibited in the General Appropriations Act from settling a case for more than $250,000 without seeking additional funds to do that.
Does state law set out a process for seeking funding for such a settlement?
It does.
Did the Office of the Attorney General follow that process?
Yes, we did.
Do you know whether funding was appropriated?
It has not been appropriated to this date.
Has the Office of the Attorney General paid out a single dime on this settlement?
It has not.
As far as you're aware, has a single dime of taxpayer money been spent funding that settlement?
It has not.
Who decides whether that will ever happen?
At this point, ultimately, the legislature will.
The House and the Senate?
Correct.
It's up to them whether to fund it.
That's right.
The Attorney General can't force them to do that, can he?
He can only ask.
Let's pull up Texas Government Code section 554.010. Your Honor, this is just a statute. I'm not offering it as an exhibit. It's going to be up on all of the screens. Mr. Arroyo, if you could zoom in on that. And I have paper copies for the witness and the court and opposing counsel, if that would be helpful.
Now this will work.
Are you familiar with this provision in the Whistleblower Act?
Yes, I am.
Can you explain in English what the statute means?
So this is essentially a reporting requirement. There's two parts to this. When you pay out on a settlement or judgment in a Whistleblower Act case, the agency is required to essentially put together a report on that case. And following that report, the state auditor's office may initiate an audit or an investigation of basically what went into what happened with the Whistleblower Act complaint. And if the SAO initiates that investigation, then they must follow up with a report to several entities on improvements that can be made, things that can be changed to prevent this from happening again.
So let's break that down. Let's go piece by piece. If the settlement is consummated, the Attorney General's office has to do what?
It has to put together a brief memorandum describing the facts and the disposition of the suit, and it has to provide that to the state auditor's office.
Okay. The Attorney General's office has to prepare a memorandum describing the lawsuit and send it to the state auditor's office. What happens after that? What does the state auditor's office do with it?
The state auditor's office will review the report, and not later than the 90th day after that report is submitted, the SAO has the option to investigate the governmental entity or conduct an audit.
Let's just pause right there. Mm-hmm. They have the option. Has the Attorney General's office been contacted by the state auditor's office regarding this provision in connection with the Brickman versus OAG matter?
Yes.
And what's your understanding of that contact from the state auditor's office regarding this statutory audit?
We were made aware of the existence of the statute, and they just wanted to bring it to our attention in light of the settlement road that we were on to make sure that we were aware of this requirement.
The audit's coming.
That's right.
And under this statutory audit, who would have received the state auditor's report?
The Legislative Budget Board and the Legislative Audit Committee, and the governing board of the chief executive officer of the entity involved.
What would that report contain pursuant to the terms of the statute?
The SAO's report would include recommendation on changes that would be necessary to correct the problems that gave rise to the whistleblower suit.
Mr. Arroyo, could you pull up the text of Article 8, please? If I'm understanding your testimony correctly, the OAG's been notified of the statutory audit by the state auditor's office, and those findings and recommendations will be given to the legislature under the terms of the statute, correct?
That's right.
Are audits and cover-ups the same thing?
I'm sorry, could you repeat that?
Is an audit the same thing as a cover-up?
Did you say a cover-up?
A cover-up.
No, it is not. It's kind of the opposite.
If someone's trying to, conceal their wrongful acts, should they subject themselves to an audit, in your opinion, as General Counsel of the Attorney General's office?
No.
Do you know whether the state auditor's office likes to conceal facts when it conducts an audit?
I do not believe that is the way they are wired.
I don't believe so either. And of course, we talked earlier, your testimony is that the allegations underlying the facts at issue in this impeachment have been reported since they happened. That's your understanding.
Correct.
You've seen reports in the media frequently about the goings-on at the Attorney General's office.
That's right.
Texas Tribune seems to have a story every other day about the Attorney General's office, don't they?
There is a lot of coverage.
Do you have any personal knowledge of Ken Paxton ever forming an agreement with Nate Paul and accepting a bribe?
I have no personal knowledge of that.
And do you have personal knowledge of anything to do with Laura Olson?
I do not.
Okay. Do you have any personal knowledge of any vast criminal conspiracies involving misuse of OAG resources?
I have no such knowledge.
If there were such a conspiracy, would you still be working at the Attorney General's office?
No, I would not. I accepted promotion in this agency at a very critical time, and I assured myself and assured my wife if there were ever anything that I saw that were illegal or unethical, I would step away. I'm still here. I'm proud of the work we do. I'm proud to serve General Paxton. I'm proud to be part of this agency.
Thank you, Austin. Pass the witness.
Ms. Epley, your witness.
Thank you, Mr. President. Hi, Mr. Kinghorn.
Good afternoon.
Have you and I spoken before?
We are old friends now.
That's right. Is it fair to say that you have been my contact to get documents from the Office of the Attorney General?
That's right.
And that our first conversation went well, but subsequent ones got a little chillier?
That's fair.
Now, we played respectfully with one another, right? No one was rude?
That's right.
Okay. Is it also accurate, though, that right after I would have private conversations with you as an officer of the Office of the Attorney General, particular details of our conversation would show up in Ken Paxton's filings?
Objection, Your Honor. Relevance, hearsay, has nothing to do with these proceedings.
Sustained.
Mr. President, I don't know that I've ever seen a lawyer open up a bigger door in regards to the credibility and bias of a particular witness, and I would ask for a little latitude.
Your Honor, this has nothing to do with credibility and bias. She's asking about litigation discovery. That has nothing to do with
I
this.
sustain the objection. Try your question a different way.
Did you receive pressure from Chris Hilton or Judge Stone to provide you information in regards to our conversations?
Not at all, and I can answer your question more pointedly.
I'm certain that he will do that, so I don't want to be rude, but I want to make sure we move forward. Did you receive pressure incoming without a conversation?
Not at all.
Did you receive directives in regards to what position you should take?
None.
So the fact that you and I would have a conversation and it would show up in their filing the next day is completely and totally made up?
Objection, Your Honor. This is totally improper. All parties, all witnesses were free to speak to both sides. That was in the Senate rules that were adopted. And it is only fair that people producing discovery talk to both sides. They certainly talked to people we were talking to. We talked to people they were talking to. That's how the entire litigation of this impeachment has gone. This is completely improper. Nothing improper happened here. And she's not only attacking the witness's character, but my character and my colleague's character. This is completely improper.
Sustained.
To clarify, then, maybe it was the subjective use of a word. As opposed to pressure, did you receive incoming communications that inquired about our conversations?
Objection, Your Honor. Same objection, and this is hearsay.
Sustained.
Okay. You talked some about MIDI, is that correct?
About you?
About MIDI, sorry, M-I-T-T-E.
MIDI, yes.
Yes, sir. You were not directly involved in that litigation?
I was not.
So mostly what you offered for us was the use of the EAM or people's signatures to validate a contract or an action, correct?
Objection, Your Honor. Mischaracterizes testimony. His testimony speaks for itself.
Sustained.
What is the purpose of the EAM?
The purpose of an EAM is to solicit and attain executive approval of an action that's being proposed to be taken or an engagement that's being proposed within the agency.
Thank you, Mr. Kinghorn. And when you personally sign an EAM, Are you signing to say, I believe this is a good idea, we should proceed? Or are you signing to confer, as general counsel, there is legal authority?
You're asking about me personally?
Yes, sir.
I would be signing generally as to legal authority.
Okay, so when Mr. Hilton asked you and you said you were giving approval, it means consistent with your job, that's an available option that we can justify, not this is my idea, I suggest we do it.
Objection, misstates testimony.
He can answer, Your Honor, if it's within his knowledge. Thank you.
I think that everyone's, depending on their role, their reasonings for going into their signature is a little different. For my role as general counsel, I'm primarily focused on whether the agency has the legal authority to take the action proposed.
And to draw an analogy then, Ryan Vassar, for example, signing Brandon Kamek's contract is approval that it's a legal justified position, not that it's the right one.
Objection, Your Honor. Assumes facts not in evidence with this witness.
Sustained.
But your approval is about legal authority, yes or no?
Yes.
Okay. I'm going to turn your attention for a moment to the PIA. Are you aware of incoming public information requests as to Ken Paxton's email, Signal, or Proton?
Typically, no. If a PI request you're referring to is directed exclusively toward the Attorney General, that's probably not a request that would come across my desk.
I think I want to be more specific. Are you personally aware of any PIA requests ever for the text messages, Signal account, or Proton of Ken Paxton?
Objection, Your Honor. Relevance.
Overruled.
There's been a great number of PIC requests concerning the Attorney General's personal communication devices. I don't remember with specificity as to the specific types of communication you're referring to.
So you're telling the Senate you do not know if a PIA has ever been requested for his texts?
If you phrase it that way, then yes, I am aware that there have been PIA requests for his text.
Are you aware of PIA requests for his Proton email?
I'm not personally aware of them, or at least do not recollect.
Are you personally aware of PIA requests for his Signal?
I'm not personally aware or don't recollect at this point.
Are you personally aware that he has those accounts?
Again, objection, Your Honor, to the relevance of this. It has nothing to do with anything this witness has testified about. It has nothing to do with anything in his personal knowledge, and nothing to do with any of the articles of impeachment.
Overruled.
I do not have any personal knowledge on the use of a Signal account. In terms of, as I have reviewed the documents in terms of producing to you through subpoena requests, I have seen that there was a Proton email account that wasn't included, I believe.
Are you familiar with the fact that either the Proton or the Signal was set up by Office of the Attorney General IT staff?
I am not familiar with that.
Do you think that you should be if it's true?
Not necessarily.
Okay. Are you aware of the fact, either through a PIA request or the subpoena authority of this Senate, we were not provided any documentation related to Signal or to Proton email for business conducted on behalf of the state of Texas by Ken Paxton?
Objection, Your Honor. Lacks foundation, lacks personal knowledge. The witness has testified that this is not within his scope and that he doesn't know anything about any of these. This is an argumentative question with no foundation.
Sustained.
Did you personally respond to our discovery requests?
Yes, I did.
Did you personally have a conversation with me about Proton email?
Objection, Your Honor. Hearsay.
I don't know what to say to that, Your Honor. We're both here.
I'm going to overrule. You can answer the question.
Thank you.
Can you restate the question for me? I'm sorry.
Did you personally have a conversation with me about Ken Paxton's Proton email?
I do remember that conversation, yes.
Do you remember telling me that you knew it existed but couldn't provide me any of those documents?
I did not say that.
You didn't tell me that you knew that there was a Proton email account, but you didn't know anything about it.
Objection, Your Honor. Asked and answered. She's attempting to impeach the witness with a conversation that she thinks she recollects. This is improper.
I'm certain I recollected, if that helps.
Overruled. You did ask, he did answer, but overruled.
Okay, so let's try this one last time. Will you tell the ladies and gentlemen of the Senate if you provided us any proton or signal documentation for Ken Paxton?
Sorry, can you ask it a little bit more slowly, just the echo is...
That's fair, I speak quickly. Will you tell the ladies and gentlemen of the Senate whether you did or did not provide us any document in regards to Ken Paxton's proton or signal account?
We did not provide any documents related to a proton or signal account.
At one point during the questioning, I think what you had said was the Office of the Attorney General is Ken Paxton's law firm. Did I get that right?
Objection, misstates prior testimony.
It was in court today and a moment ago on the subject of Gross.
Overruled.
Thank you.
I'm analogizing, but yes, I did say that.
But of course, that kind of brings me to my next point. As a prosecutor, your job is to zealously advocate for the, your job is to seek a true and fair, I've forgotten my oath. As a defense attorney, your job is to zealously advocate. But as a civil attorney who works on behalf of the Office of the Attorney General, what is your oath? What are you supposed to do? What's the most important part of being a lawyer for the state of Texas?
Objection, Your Honor. Compound question.
Overruled.
I would say the most important part of my job as a public servant is to faithfully serve my principal and the people of Texas.
Do you believe your principal and the people of Texas to be different? Who do you think your client is, Mr. Kinghorn?
Who is my what?
Who is your client?
My client?
Yes.
Is the Attorney General.
Would you believe me if I told you that when you work for the Office of the Attorney General, you work under his authority and for him, but your client is and only ever is the state of Texas?
Objection, Your Honor. Argumentative, contains a legal conclusion.
Sustained.
Do you believe me when I say that, or do you agree with it now as you sit here?
Objection, Your Honor. Same.
Yeah, same question. Sustained.
You were asked questions about Brandon Kamek, and you relayed a conversation in which he'd called to find out about payment. Do you recall that?
I do.
And can you tell us what month and year that was?
Not with any greater specificity than what I indicated earlier.
I didn't hear you, so would you tell me again?
Sure. I believe it was after I was promoted general counsel, which would have been sometime during the month of November. But it wasn't necessarily during November. It could have been December. I don't remember exactly when it happened.
Okay. So Ryan Vassar was part of bringing you into the Office of the Attorney General, is that correct?
He was.
And Ryan Vassar was a friend of yours, correct?
Yes.
And is it fair to say that you liked and respected Ryan Vassar?
Yes.
And when he was summarily dismissed from the Office of the Attorney General, you rose to his position somewhere around November, correct?
Objection, Your Honor. Argumentative and assumes facts not in evidence before this witness. Moreover, I don't know what this line of questioning is intended to do other than improperly bolster the character of some witness who's not here. The door has not been open to that, so that aspect of this questioning is also improper.
Overruled.
I'm sorry, could you give me the question again?
Were you promoted after Ryan Vassar was fired?
Eventually,
yes or no?
Yes.
Thank you. And it was after that that you had a conversation with Brandon Kamek, and Brandon Kamek is asking your office about payment because despite the fact that he's been employed since September, he's never been paid. Is that right?
That's right.
And as of November, there was no contract in place, right?
There was a valid contract.
Then why was he never paid?
At one time. By the time Mr. Kamek reached out, I believe the contract had been closed at that time. Just trying to be specific.
So what I'm asking you is, there's a secret, private contract signed only by Ken Paxton, not kept in the Office of the Attorney General at some point in this storyline, correct?
Objection, Your Honor. Argumentative, assumes facts not in evidence before this witness.
Sustained.
I don't know how else to do that. The defense's entire position is that Ken Paxton signed a contract with Brandon Kamek, correct?
Objection. This witness has been subject to the rule and doesn't necessarily, doesn't speak for the defense. It's the same question. It's argumentative. It's a sidebar. You've sustained the objection.
If I may, he was questioned at length in regards to the OAG report, Any person who's read it once or skimmed through knows that this is their position. It's not a violation of the rule. It's a question he opened.
Objection, argumentative, and lacks foundation. She hasn't laid that he knows anything about that aspect of the OAG report, and if she wants to ask that question, she can do it, but she has to lay the foundation for it and do it properly.
I'm happy to do that.
Dane, go ahead.
Did you read the Office of the Attorney General report?
I have read it, yes.
Okay, so on page 5, it reads, position taken by the Attorney General in this litigation was adverse to Nate Paul and in support of higher settlement amount to be paid by Nate Paul. Do you recall that being their position?
Objection, Your Honor. If she's reading from a document, I don't understand what it is, and I don't have it.
He's testified that he's read the Office of the Attorney General report.
I didn't understand.
He's been questioned in regards to its veracity. I intend to take him through a list of false and misleading statements to get his position and then challenge him with the testimony of the whistleblowers as allowed by the rules.
Objection overruled.
In regards to the Mitty Foundation, on page 5, it says the position taken by the Attorney General in this litigation was adverse to Nate Paul. You understand that's his being Ken Paxton's position, correct?
Objection, Your Honor. There's been no testimony about Ken Paxton's position, and there's no, are we talking about the report or are we talking about Ken Paxton? I'm still confused as to what we're doing here.
Sustained.
Is the Office of the Attorney General report in question published on the AG's website?
I'm sorry, say that again.
Is the Office of the Attorney General report published on the AG website?
Yes, it is.
And do you have to have either title status, meaning Ken Paxton, or the first assistant in order to publish it?
Yes, that's a fair statement.
And therefore, every statement put onto that website is adopted and made on behalf of Ken Paxton, correct?
I believe that the report is issued by the Office of the Attorney General. Whether that extrapolates to a legal position that Ken Paxton holds pursuant to this proceeding, I'm not going to go there.
So as an officer of the court and a government agent, you're not going to honestly say that anything published on the Office of the Attorney General website is the responsibility of Ken Paxton and something he should be held accountable for? That's your position?
Objection, Your Honor. Argumentative. She's demanding that this witness make a legal conclusion that he's justified, that he's just testified that he cannot make.
He is the general, thank you. Is your position that he cannot be held accountable for what he posts on the website?
My position is that I can't speak to the Attorney General's legal positions.
Isn't that your entire job duty?
Objection,
Let him answer. Let him finish his answer.
Thank you.
No, it is not. My job is to provide advice and counsel to my client, the Attorney General of Texas.
Okay. So if you had to choose between the state of Texas interest and Attorney General's interests, whose do you choose?
I do not see them in conflict.
Okay. Then back to this point. Do you or do you not, as attorney for Ken Paxton, think that he is held accountable for the items that he posts on his website?
I don't know what you mean by held accountable. That's a very vague question.
I'll help. Are you familiar with the Texas Rules of Evidence?
Somewhat. I am general counsel, not a litigator.
Do you understand what an admission by adoption is? Or an admission because it's made by a representative? Or an admission because it's made by an employee?
I'm aware of those rules.
Do you believe that those things would apply in appropriate context to Ken Paxton?
That's not something that I've researched specific to this proceeding. I don't have an answer for you on that.
I think we're all clear on you not wanting to answer this question, so I'll move along. I'm going to give you a series of statements then, and I would like for you and I to discuss them. This investigation revealed the OAG's intervention worked to the foundation's advantage on mediation. If I was telling you, or if that statement's about Mitty, and you have Ryan Bangert, Josh Godby, Darren McCarty, and Ray Chester all disagreeing with this statement, would even them disagreeing change your opinion as to it being valid?
Objection, Your Honor. Assumes facts not in evidence before this witness as to those other folks' positions. I don't have an objection to her questioning the witness about a document that I believe is in evidence, but I think in fairness he should be provided with a copy of it.
Sustained.
So earlier when Mr. Hilton asked you if you believed in the OAG report, you're not actually saying anything in it is true or not true, or that any of us should really entertain your opinion on it, right?
Objection, argumentative, misstates testimony.
Overruled.
Can you restate the question?
Your opinion on the Office of the Attorney General report being truthful is irrelevant to this proceeding because you will not address the statements within it. Is that accurate?
I don't agree with the question as you phrased it.
Okay. Then let's talk about the foreclosure letter. You went into great detail in regards to the distinctions. You relied on 418. Is it accurate to say that applies to mayors and local subdivisions, but not Senator Hughes?
That's correct.
And so Senator Hughes's authority or name wouldn't be necessary if that was the basis of that letter, correct?
I do not believe it was necessary. That's correct.
That's a different question. If the Attorney General was relying on 418, Senator Hughes's approval would not be necessary, correct?
If I understand yes, that's correct.
In regards to 402.042, that you do need an official requester for, correct?
That's right.
And if it was an informal guidance, then no requester is needed at all, correct?
That would be my position, personally.
So in regards to items 1 and 2, you wouldn't need to involve Senator Hughes at all, let alone use his name to put forth an opinion that he certainly would never have approved of, right?
Objection. Assumes facts not in evidence. Moreover, she's stating a juror's opinion without following the rules.
Sustained.
Okay, last in regards to your credibility and the Attorney General's reliance on you. Is it fair to say that you represented him in a bar grievance relying on in a government filing or a court filing? And you took the position that the Attorney General was not subject to the bar rules or the state Texas ethics rules?
Objection, Your Honor. Assumes facts not in evidence.
I'm asking him, he's on the stand, it was his position.
And you're characterizing that grievance and that litigation. You're mischaracterizing it. You haven't established that any of those things are true with this witness.
That's the purpose of the questioning.
Overruled.
Did you or did you not take the position that the Attorney General of the state of Texas is not beholden to state bar ethics rules?
Objection, relevance. That doesn't have anything to do with an article of impeachment.
Overruled.
Ms. Epley, I'm not sure which, can you be more specific about what complaint you're referring to? I don't have recollection when I sit here as to specific.
Does it feel appropriate to you that you would ever, for any reason, for any purpose, indicate that the Attorney General of the state of Texas was not beholden to bar ethics rules?
I don't think that's what we said at any point.
Pass the witness.
Mr. Kinghorn, do you know if any proton mail or signal documents that would be responsive to their subpoena exist?
I do not.
Did you conduct a diligent search for those documents on behalf of the Office of the Attorney General?
I conducted a diligent search of all documents that we had in our custody and control.
Do you have an obligation to produce documents that don't exist and that aren't in your possession, custody, or control?
I do not.
Can I have 1 moment, Your Honor? Pass the witness, Your Honor.
Ms. Epley, are you coming back?
No, I have no further questions for Mr. Kinghorn. Thank you.
May he be excused.
May we approach on a quick housekeeping matter? It's just the admission of some records I left at the podium, frankly.
May I excuse the witness? Yes.
That's fine with us, Your Honor.
Okay. Yes, you can approach.
And so Austin Kinghorn, likely the last witness before they break for lunch. Right this moment, there's some evidence that the prosecutors want to talk about having admitted. Austin Kinghorn, Associate Deputy General for Legal Counsel and a witness for the respondents for General Paxton and his attorneys. They walked through each of the articles of impeachment with him. He testified that the emergency or midnight foreclosure opinion that came out over the first weekend in August and that restricted the number of people at outside foreclosure sales, and we've heard testimony benefited Nate Paul. He said it was not unique, that it happened a lot, especially during COVID, and that he didn't see it as any individual benefit to Nate Paul. he talked about some other issues as well as it relates to the articles, and we'll let you hear part of that conversation in a minute. But Aaron Epley on cross-examination went in rather aggressively on Austin Kinghorn. First, suggesting, and there was staccato objections to her line of questioning by Chris Hilton, but Epley saying, our first conversation went well, following conversations were chilly, and that things I talked to you about right after I would speak with you, after we would have conversations, they'd show up in the Attorney General's documents and files, suggesting that he was telling specific information. Chris Hilton strongly objected and saying, listen, this is how this entire case is going. Both sides have talked to the witnesses throughout this litigation. But she was trying to make a point that whatever she was requesting was being shared almost immediately. One of the things that was interesting as well, at one point she asked Austin Kinghorn who he worked for, who was his client, and he said his client was the Attorney General. And subsequently to that, she rephrased it, asking again. He said both the Attorney General and the state of Texas, or the people of Texas, says he saw no conflict between the two, but kind of telling that his first response was, my client as a lawyer in the AG's office is to the Attorney General. He's my first client. That office is to work for the state of Texas. And she's trying to just get that in the atmosphere, I think, in the minds of elected senators serving as jurors who understand they too work for the state of Texas. So again, this is a debate over some additional documents, evidence that the prosecuting attorneys for the House managers want to have admitted, having this sidebar now. One of the articles also spoke to, or speaks to, I should say, quote unquote, abuse of funds, using taxpayer dollars to pay the whistleblower settlement. Under direct exam by Chris Hilton, Austin Kinghorn was asked about that. I believe that's Article 8.
Members, we will take our lunch break now until 1:30. Yes, and there's a short meeting before that.
1:30. And the response was that it hadn't been paid. It hasn't been decided whether it will be paid, who will be paid. And the question was, who makes that decision? And the answer, of course, were the elected members of the House. And Chris Hilton followed up with, can the Attorney General force them to do that? And the response was no, he can only ask, suggesting there's been no misuse of taxpayer dollars because nothing has been paid, and if it's paid, it will be the decision of the elected representatives of the people of Texas. What I want you to hear goes back to an exchange around this document that was produced by the Attorney General's office in August of 2021, over 300 pages long, if I remember, that cleared Ken Paxton of any wrongdoing, of any abuse of power, cleared him of any bribery allegations. This, again, document was produced by an investigation into Ken Paxton by his office. Listen to the exchange between Chris Hilton and Austin Kinghorn as he's asking him questions about this.
Are you aware of the Attorney General's Office internal report regarding the events underlying this impeachment proceeding?
Yes.
And broadly speaking, what is that report as you understand it?
That report is the findings of a 10-month investigation that was conducted internally at the Office of the Attorney General concerning the allegations that the whistleblowers raised.
Did you ever review that report?
I did.
How many times? What was the nature of your review?
2, no more than 3 times. I was provided a copy and asked for general feedback on the document, proposed edits, revisions, things along those lines.
Were you ever directed by anyone to make sure that the report was a sham?
No.
Were you ever directed to make sure it included false or misleading statements?
Absolutely not.
Are you aware of anyone else receiving such a direction?
Absolutely not.
What would you have done if you had identified a false or misleading statement in that report when you reviewed it?
If I had identified a false and misleading statement, I would have immediately raised that issue to the folks who are working on the report for consideration.
Now, when that report was released, August 2021, a couple of years ago now, an attorney for the whistleblowers at that time called it a, quote, half-baked exoneration cooked up by Ken Paxton staff. It was an internal report. It was an internal investigation. Not uncommon for law enforcement to do investigations of themselves all the time, but maybe law enforcement, maybe they don't investigate the top person in their office. They bring in someone else to do that investigation. Just putting that out there in the atmosphere. Listen, we're going to take a break now. Want you to make sure you're back in the stream with us at 1:15. 1:15. They're going to return from the lunch break at 1:30. But at 1:15, we're going to be joined by Stephen Dial, who is in Austin for what we anticipate will be the last days of this impeachment trial. And we're going to be joined by him live from Austin, talk about the morning testimony and the last 2 weeks, and get ready for the afternoon session. So we'll see you back in the stream on all platforms, 1:15. All right, see you then.
Whether the appearance of a deputy attorney general in district court in Travis County would be unusual.
I only did that one other time during the course of my role, and that was when Google contested our right to get information under a confidential information demand issued by our antitrust division.
But in
my recollection is that it was to be a lengthy hearing, yes.
Were you prepared?
I was not prepared at all.
What did you say to him?
I said it didn't make any sense for me to do it because I wasn't prepared and because of the time and all the other things I had scheduled that day.
And what did he say to you?
He said, well, then I'll do it.
He'll do it? General Paxton will himself go to district court in Travis County to argue a motion?
Yes, that's what he told me.
What did you think about that?
Well, I talked him out of it.
What?
I talked him out of it.
Again,
I guess what I thought about it was that it was a terrible thing for him to do.
And why?
Because he was the Attorney General of Texas. He never appeared in court, not once, not a single time. And, you know, as a representative, right, as a lawyer, I should say, let's put it that way. And for him to make an appearance in that type of hearing sends a very odd message. And it didn't seem appropriate for our office to have that sort of level of involvement in a case like this at all.
I'd like to get a yes or no to that. Was that in the best interest of the Mitty Foundation or the public interest in it, or was it in the best interest of Nate Paul?
Well, every understanding everything that was going on and the fact that the Mitty Foundation thought that there was far more return on this investment available than I think even the $10.5 million settlement that had been reached before. No, because it was clear that we were not going to settle for $10.5 million. The Mitty Foundation was not going to settle for $10.5 million. I'm sorry. They were not going to get $10.5 million because the world-class entities were not going to offer it. And they thought that they could get more than the 10.5 through litigation. And so no, we were not helping the Mitty Foundation.
Did you learn or see subpoenas, the grand jury subpoenas, that had been issued to players in the Mitty Foundation case?
I saw a criminal grand jury subpoena that had been issued to a bank.
What was your reaction to that?
I was stunned.
What do you mean? Explain it.
I saw a criminal grand jury subpoena directed to a bank that was clearly seeking information that would have aided world-class Nate Paul's efforts against the Mitty Foundation.
Why is that bad?
Well, it's one thing is it's lawyer ethics 101, so that was the first thing that came to my mind. We are weaponizing the criminal process to aid a civil litigant, and that is a big no-no.
Why did you do that?
I did it because I believed at that point that the AG's office intervention into the Mitty Foundation was unfounded, and as I said, I believed unethical, and I believed it was actually attacking a charitable trust as opposed to defending the public interest in a charitable trust. I believed I had an ethical duty under our rules because we had now used the criminal justice system essentially against the Mitty Foundation. And, frankly, my name, my colleagues' names, including Jeff Mateer, Josh Godby, I think Ryan Bangert, and now my recollections refresh, Rachel Obaldo. Importantly, the Attorney General's name, and maybe most importantly, the state of Texas's name, have been used and invoked improperly, clearly improperly, against the Mitty Foundation that was a public charity.
Were you called a rogue employee?
Absolutely.
Do you believe you were a rogue employee?
No, I believe that I was doing what I had to do, as unpleasant as it was, and it was quite unpleasant.
Had there ever been any settlement discussions prior to that?
No.
Had there ever been any indication while the lawsuit was pending and the election was in the future, during that 2 years, was there ever any indication or suggestion that about a possible settlement?
Never.
Right. Do you know of any circumstances that changed and led to their reaching out to you to discuss a settlement?
Ken Paxton was reelected.
Was he reelected without knowing anything, without the public being told any of the real facts, and so in the discovery with depositions or so?
I would say it's even worse than that. I think Ken Paxton lied to the public for 2 years about our case. So not only did we not have discovery, he did the opposite and lied to the public about our allegations.
Let me ask you, if you can, then what I want to do is to go to Exhibit 460. I want to move to introduce 469 and 470, but I first want to ask a couple of questions about it. With the original settlement that everybody's heard a good deal about, was there a proposal that you actually personally, individually held up from reaching a settlement?
I did not go to the mediation.
Hold on. We're going to try to do this in a question-answer way. So, was there a suggestion of a mediation sometime in February?
Yes.
All right. And who all went to that mediation?
My other three co-plaintiffs went: Mark Penley, David Maxwell, and Ryan Vassar.
And out of that mediation, did the three of them reach a settlement?
They did.
And what was this amount that they settled for?
$3.3 million.
Why did you not go to the mediation?
Because I did not want to settle the case.
Why did you not want to settle the case?
Because I wanted to be vindicated for what happened to me and my colleagues, and I did not want to settle the case. What happened to us should never, ever happen to any other public servant in Texas.
What were your conditions before you would ever agree to consider settling?
I had 3.
What were they?
Ken Paxton apologize for calling us rogue employees and admit that we did what we thought was right, was the first one.
That's number 1.
The second one was the Third Court of Appeals had ruled in our favor that the whistleblower law applies, and I wanted him to agree not to move to dismiss that.
In other words, you had a winning opinion on intermediate court level, and you wanted an agreement that they wouldn't challenge that agreement, that ruling?
I did, because I wanted future Texas public servants to know that the whistleblower law applies in this state.
All right. And what was your third demand?
That Attorney General Ken Paxton remove a disparaging statement where he called us rogue employees that was on the OAG website.
You said you had become concerned. You expressed some of those concerns. What was the focus and what was giving rise to it for you personally of September 29th and 30th of 2020?
I witnessed Attorney General Ken Paxton do brazen things on behalf of Nate Paul. He abused the entire office of the Attorney General of Texas to benefit Nate Paul. And it got worse and worse and worse as the year progressed.
The historic impeachment trial of Texas Attorney General Ken Paxton is underway. Hello, I'm Steve Eager.
Hello, everybody. I'm Heather Hayes. The proceeding is political, not criminal, but it does pose the greatest threat so far to Paxton's career. Through his attorney, Paxton entered not guilty pleas to 16 articles of impeachment. The case centers on his relationship with real estate developer Nate Paul and whether Paxton abused the powers of his office to help Paul and to cover up his own wrongdoing. Fox 4's Sean Rabb in now with more on the trial coverage. Sean.
And the House managers in opening statement said the now suspended Attorney General used the office for his own benefit and should be removed. Paxton's attorneys called the charges untrue and incorrect. And now we also know Paxton cannot be forced to testify.
Our first order of business is to address 24 pre-trial motions.
And senators serving as jurors voted no to 16 defense motions to dismiss everything from articles of impeachment to certain evidence. In this political trial where the Attorney General is accused of misusing his power, abuse of office, fraud, and accepting bribes from friend and political donor Nate Paul.
This court notes that many factors and circumstances in this proceeding lean more on criminal in nature.
One early victory for Paxton, Lieutenant Governor Dan Patrick deciding that many of the rules in this impeachment proceeding lean towards the rules in criminal court, including whether the accused can be forced to testify.
And the House of Managers have repeatedly compared the actions of the House of Representatives to a grand jury. As they prefer the articles of impeachment, grand juries are utilized only in criminal cases. Therefore, the motion is granted. The Attorney General cannot be compelled to testify.
We never heard from Paxton during day one of proceedings. Standing between his attorneys as Tony Busby entered not guilty pleas to each article of impeachment.
Attorney General Paxton, how do you plead?
Stand by that report and therefore plead not guilty.
Your Honor, objection.
Busby's not guilty pleas with emphasis brought an objection from House Manager's attorney Rusty Hardin.
I ask that he just be instructed to plead not guilty or guilty, whichever he chooses, but not to be making speeches to his lawyer.
Sustained.
After lunch, Ken Paxton did not return to the chamber-turned-courtroom where House Manager Andrew Murr painted Paxton as using his office and power for personal gain. Murr arguing there's much voters don't know about Paxton's alleged misconduct when they reelected him.
Mr. Paxton has been entrusted with great power. Unfortunately, rather than rise to the occasion, he has revealed his true character. And as the overwhelming evidence will show, he is not fit to be the Attorney General for the state of Texas.
Busby, Paxton's lead attorney, told senators what was happening here was a whole lot of nothing, that Paxton did nothing wrong, and then turned his remarks pointedly to the senator jurors with a swipe at media reporting, much of it based on troves of documents published by the impeachment managers.
Have you already decided based on what is politically expedient or what's best for you personally? Or is it even possible to get a fair hearing? Especially after this case has been tried in the press, Ken Paxton has been convicted in the press based on ignorance, innuendo, and outright lies.
Late this afternoon, the first witness took the stand, James Mateer, longtime second in command at the Attorney General's office, one of 8 who went to the FBI, but not one of the 4 whistleblowers. Through him, House managers and Attorney Rusty Hardin are starting to try and build this overly interesting relationship that Ken Paxton had in the affairs of Nate Paul. Testimony has concluded for today. Will begin tomorrow morning at 9 a.m.
Okay, Sean Rabb, I guess it's not like a criminal case. It is, but it's not. He doesn't have to testify, and those guys aren't jurors, the men and women in the Senate, so.
It's like a criminal case, has all the leanings of a criminal case, but won't have the criminal outcome if he is found guilty.
There's outside pressures, too, politically on all of them. All right, Sean Rabb, thanks.
All right.
Among the key moments during testimony in Ken Paxton's impeachment trial was the meeting a prosecution witness described where Paxton admitted having an affair.
So the witness, a former top aide in the Attorney General's office, said that explains some of Paxton's unusual behavior. But that witness testified the real cover-up happened when Paxton resumed the affair. And more details were revealed about what he and others told the FBI about Paxton's questionable dealings with an Austin businessman. Fox 4's Blake Hansen in studio tonight to take us through today's testimony. Blake.
Steve and Heather, this was effectively the first full day of testimony, much of it centering around Paxton's former top deputies and what they witnessed on the job.
I was quite frankly sick of dealing with Nate Paul.
It was another one of Ken Paxton's former top deputies and whistleblowers taking the stand late Wednesday. Ryan Bangert talked of donating to Paxton's campaign before joining the office and being a fan of Paxton's work.
I believed in what he was doing. I believed his policies were the best for Texas. That's why I joined his office in 2019.
But Bangert says in 2020, Paxton began asking him to intervene in matters involving Paxton's friend and campaign donor, businessman Nate Paul. At the heart of prosecutors' case are accusations Paxton allowed Paul to use the AG's office to his benefit. Bangert says Paxton requested they intervene in an open records dispute, a dispute between Paul's businesses and a charity, and more.
Is that the 3rd time you've now been asked within 6 months to review a matter that involved Nate Paul?
Yes, yes.
Right. So at this time, how would you characterize your feelings about whether or not the AG's office ought to be getting involved in anything that involved Nate Paul?
My feelings were that I was becoming increasingly concerned.
Bangert described unusual behavior when Paxton asked them to rewrite an opinion about foreclosures to do the opposite of staff's suggestion.
It was bizarre.
And why was it bizarre?
He was acting like a man with a gun to his head.
In what way?
Anxious, desperate, urging me to get this out as quickly as humanly possible.
Bangert described taking off one of his staffers' signatures and adding his own to the opinion for fear it would tarnish the young man's career.
I changed it to go out under my signature.
And why?
At the end of the process, I had become very alarmed by the Attorney General's behavior. I had promoted Ryan Vassar into that position myself, and I felt a degree of responsibility to him.
Before Bangert, we heard from former First Assistant Attorney General Jeff Mateer. He recalled in September 2020 how Paxton and his wife, State Senator Angela Paxton, called an emotional meeting with senior staff.
Mr. Paxton revealed that he had been engaged in an extramarital affair and asked for our forgiveness.
But then Mateer says he learned the affair had resumed. He and others alleging Paul manipulated Paxton for favors to help cover it up. On cross-examination, Paxton attorney Tony Busby and Mateer were heated at times. Busby sought to downplay Paul's influence over Paxton.
In 2018, what percentage Nate Paul's campaign contribution was with regard to the total amount raised by Ken Paxton? Well, if your math is correct on this demonstrative, it's there, but I wouldn't have known that then, no. 0.37%.
Busby also directed questions about who knew what win about reporting Paxton to the FBI.
You were involved in staging a coup, weren't you?
Absolutely not.
You were staging a coup, weren't you?
Absolutely not.
The prosecution is not yet done with its questioning of Bangert, and he has yet to face cross-examination from the defense as well. Steve and Heather.
All right, Blake, likely see you tomorrow and maybe the rest of the week. Thank you very much. There was dramatic and at times contentious testimony today at Ken Paxton's political trial in the Texas Senate. We also saw emotional moments from Paxton's former employees who went to the FBI complaining that their boss was allowing the Attorney General's office to be misused by a political friend. Fox 4 Sean Rabb, watching today's testimony, is here with the highlights again. Sean?
Steve, another whistleblower in the Attorney General's office who did not file a lawsuit said he felt the AG's office had been hijacked to help developer and Paxton donor Nate Paul. And Ryan Bangert testified the group of 8 who went to the FBI were not staging a coup, but wholly concerned.
Did you consider it a mutiny?
It was not a mutiny.
How would you characterize it?
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
That's how Ryan Bangert testified about going with others to the FBI, concerned about the relationship between Attorney General Ken Paxton and real estate developer, Republican donor Nate Paul. That assertion, though, challenged under, at times, combative cross-examination by Paxton attorney Anthony Oso Jr., with Lieutenant Governor Dan Patrick instructing the witness to answer.
Now, at no point after you reported to law enforcement were you terminated from your position. It's a yes or no question, Mr. Bangert. Were you fired or were you not fired?
I was constructively discharged.
Now, I asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively discharged.
Bangert testified Paxton took him to a lunch meeting with Nate Paul, who complained about being treated unfairly and wanting the AG's office to intervene in his financial dispute with a nonprofit foundation that invested millions in some of his Austin projects.
What was your impression about that, what that whole meeting was about?
The strong impression that I had developed was I had been summoned to that lunch by Nate Paul to hear out his grievances and to convince me to get on board with the Midi Foundation intervention program.
All of this happening while the AG's office was wrestling with much bigger issues, from a Google lawsuit and COVID.
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
One of those issues, COVID-related. A midnight order in August 2020 restricting to 10 the number of people attending outdoor foreclosure sales pushed for by Paxton. Bangert said he was against it, later learning Nate Paul benefited because he had multiple properties in foreclosure.
The Attorney General was determined to harness the power of our office and to fulfill the interest of a single individual against the interest of the state.
Under cross-exam, this hard line of questioning.
You're here to testify in the court of impeachment. Do you not remember the day that you went behind Ken Paxton back to the FBI? Do you not remember that?
Sir, we did not go behind the Attorney General's back.
Did you tell him you were going to the FBI? Yes or no?
Sir, we did not go behind the...
Mr. Bangert, I'm asking you yes or no questions. Did you tell Ken Paxton that you were going to go to the FBI?
On September 30th, we did not.
It's a yes or no question, Mr. Bangert.
It's not a yes or no.
It is a yes or no.
The mood in the chamber turned courtroom changed as witness Ryan Vassar, former Deputy Attorney General for Legal Counsel, tried to hold his emotions as he talked about being called rogue by his boss, Ken Paxton.
And it's contrary, the statement of being rogue is contrary to the years that I dedicated my life to the state.
U.S. Senator John Cornyn, on a call with Texas media today, called the impeachment trial very deeply disturbing and painful to watch. Continues tomorrow.
All right, Sean, thank you very much. We'll see you soon. As we continue to cover the impeachment trial, you can watch the live stream on fox4news.com, the Fox 4 YouTube page, and when we're not in a newscast, on Fox Local. That's our streaming app on Apple TV, Roku, Android, and Amazon Fire. It's free to download, and there is no login required. Whistleblower text messages and former Texas Rangers testimony dominated day 4 of suspended Attorney General Ken Paxton's impeachment trial. Paxton was again not present in the courtroom where his attorneys attempted to tear down previous testimony. Fox 4 Sean Rabb in studio with more. Sean.
And Steve, those whistleblower text messages in a group chat days after going to the FBI about Paxton, that former Texas Ranger who was over the AG's law enforcement division, compared Nate Paul, the developer and Paxton donor at the heart of this political trial, with Billy Saul Estes. He was convicted of perhaps the most sprawling fraud scheme in history.
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
Former Texas Ranger David Maxwell, who was the Attorney General's law enforcement director, testified what he told Ken Paxton about Nate Paul after his first meeting with Paul, a meeting he was told to have by Jeff Mateer, who testified Tuesday. Maxwell had 2 meetings with Paul and his attorneys that were recorded, and a third meeting that included Paxton, not recorded at Paxton's insistence. Paul, Maxwell said, was angry, pressing for the AG's office to investigate DPS troopers, FBI agents, and a federal judge in connection with search warrants at his businesses and home.
And I told him that all you're doing is using the power and the prestige of this office for your own purpose, and I'm not going to allow that.
Maxwell says after that meeting, Paxton never spoke to him again. 2 months later, he was placed on leave. A month after that, he was fired.
You are insulting your colleagues on this group chat among friends. True?
I wouldn't describe it as insulting.
Text talk between the whistleblowers after they went to the FBI, also part of day 4 testimony. Joking about Ken Paxton and other staff in the AG's office not being smart. Ryan Vassar, who testified through tears Thursday at being called a rogue employee, posting a link in the chat to a coloring book, suggesting new staff needed something to entertain them.
It was a joke.
I believe earlier your testimony was that being called a rogue employee was very upsetting to you, right?
Yes, sir.
But this is how you talk about your coworkers. True?
Again, it was lighthearted. It was among friends. It was not made public to millions of people.
Lawyer Little tearing at previous testimony that Nate Paul's issues overwhelmed the Attorney General's office.
How many lawyers are there roughly at the Office of the Attorney General?
Roughly 800 lawyers.
How many of them ever touched anything related to Nate Paul? How many of the 800 ever touched anything related to Nate Paul?
I could speculate there may have been 15 lawyers, maybe 15 to 20.
With 20,000 active cases at any given time.
And how many of those 20,000 cases involve Nate Paul?
I would have no direct knowledge of how many of those cases would.
The cross moving to the so-called August 2nd midnight order that restricted the number attending foreclosure sales. Nate Paul had 13 properties set to be sold August 4th, 2020. Little pressed on whether it was just one of many COVID guidances being released almost daily.
Orders similar to this that were giving informal legal guidance about COVID matters were coming out of your office almost every day. True?
I'm not sure if it was daily, but we were providing advice on a regular basis.
Now, each side has been given a total of 27 hours to present their case, and we are more or less halfway through that allotted time. Testimonies ended for now, resumes Monday at 9 a.m.
Day 5 of suspended Attorney General Ken Paxton's impeachment trial is marked by a whistleblower testifying that Paxton's friend and campaign donor acted like he was the real boss of the AG's office.
The witness said he warned that Paxton could put himself in legal jeopardy by helping Nate Paul, and that Paxton expressed a personal grudge against law enforcement. Fox 4's Sean Rabb joining us in studio with more of today's testimony. Sean.
Yes, former deputy over criminal justice spent about 4 hours testifying about phone calls and meetings with the Attorney General around Nate Paul, who is the subject at the center of this impeachment trial with Ken Paxton. In a meeting with Paxton and Paul, Mark Penley informed the office would not investigate his claims any further, and that, he testified, brought an angry response from Mr. Paul.
Mr. Paul acted like we didn't understand who the real boss was. It wasn't the Attorney General, it was him. That was his body language, that was the expression on his face, the way he bowed up. He got very unhappy with us.
Nate Paul wanted the Attorney General's office to look into his allegation that laws were broken during the search of his businesses and home by state and federal authorities. Paul wanted the AG's office to investigate troopers, FBI agents, an assistant U.S. attorney, and a federal judge. Mark Penley said he and former AG Law Enforcement Director David Maxwell, who testified Friday, decided to slow walk the investigation, hoping Paxton would drop it because he thought it was crazy.
Why did you think it was crazy?
The idea that the state of Texas Attorney General's office would go investigate the federal courthouse, investigate federal agents, and also state agents that were task force officers on the raid, and those were agents from the DPS and the State Securities Board, that we would investigate a federal magistrate judge and federal prosecutors was insane.
Penley, a former deputy in the AG's office, testified in phone calls and meetings. Paxton kept pushing for Paul's claims to be investigated.
I asked him why he was so interested in this investigation when he was not